Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault. And you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case. Dati mihi Anglican for his service Latino. I didn't ask you to interrupt me.
Is that correct?
All rise. The court is now in session. Judge Newman presiding.
Good morning, good Friday morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. The weekend is upon us, but you'd know that if you were here for the podcast last night. If you missed it, you can still go back and rewatch it. We do actually, we saved them for you. Good morning, one and all. It is exciting. I've got some things to talk about that are completely not related to... They probably would have been great topics for the podcast. And for Thomas to weigh in on. But no. I thought about it, and Mrs. R.A. thought about it this morning, and now I'm going to bring it up to you because it does affect what you might be seeing here on the channel here in a little bit. So we'll talk about that after the birthdays. Don't let me forget. So remember to talk about the thing, and we will. We'll talk about the thing. We talk about things that are not relevant. Dizzy Grenade, welcome. 18 months. And I see a birthday on there. Happy birthday. Amanda H., member for 29 months. OG. Amanda, thank you so much. Not only my 49th birthday today, 2 birthdays, but my 29th month anniversary with my addict friends. That is awesome. We'll sing to you here in just a bit. Kelly H., birthday. Member for 9 months. Waiting to move on to New Color Courthouse. You'll get one here soon. I promise. All right. Welcome. Also, we have to give the internet away to Camilla Juliana, who was first in chat. Oi, Camilla. Oi. Welcome. Thanks for being first in chat. We're going to punish you with internet ownership.
Stubby little pencil.
Everything IP-related worldwide is your responsibility. Sorry, and I missed everything on the screen. Thank you for telling me. I will add it. Camilla actually is the one who told me because she's in charge of things like that. Today, at least. Let's see. Let me run. Oh, that's not it. Let's run to A. That's too big. There we go. Now let's go back, and I've got a couple people to put on the screen and thank. Dizzy Grenade, 18 months. Thank you so much. Amanda H., happy birthday. Dizzy Grenade, happy birthday as well. 29 months. OG. Kelly H., member for 9 months, waiting to move on to New Color Courthouse. And Mocha, welcome to the gallery. Kelly, thanks for gifting a membership. Kick things off this morning. That's awesome. Kelly, so generous of you. Let's do this. Let's assume that we've got all the birthdays in. Okay? Let's assume everyone got on the list. Hopefully. It is No Pants Friday. Hello, welcome. Calculator right here. I can't grab it. It's stuck. There you go. All right, Josh has them going on. Awesome. We're in capable hands. Bree Roz gifted a membership. Congratulations to the recipient, Maria Pinero Karzuski. Oh my goodness, Maria, you got me on that one. Stephanie, my 7-year-old granddaughter across the big pond was at Lady Gaga concert. She had a blast. That sounds like her ears are probably still ringing today. Barb Russell.
You don't put a diplomatic plate on a hoop.
No, you don't. Welcome, Barb. Thank you for gifting a membership. That one went to Lynn V. Congratulations, Lynn. Courtesy of Barb, you're now green. All right. Got a stubby pencil. There we go. Josh, thank you very much for putting these birthdays together. There's the buffer sound saying we're ready to sing.
Hear ye.
Oh, hear ye all. Happy birthday to Amanda H., Charlotte, Sherry, Cindy, Dane, Dizzy Grenade, Katie, Christy Queen, and Wayne. That's a one-verser if I've ever seen one. It's going to be tight, but it's a one-verser. Everyone join with me. We're going to do this and kick this off in style. Join with me on the birthday song. That means you stand up, take a deep breath, shoulders back, project your voice to the back of the room, blend your voice with your neighbor. Warm up with me, if you will. La 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 la. Here we go. Happy birthday to you. Happy birthday to you. Happy birthday, Amanda H., Charlotte, Sherry, Cindy, Dane, Disney, Grenade, Katie, Kristen, Queen, and Wayne. Happy birthday to you. Oh my goodness. I got behind a little bit, but Amanda H., Charlotte, Sherry, Cindy, Dane, Dizzy Grenade, Katie, Christy, Queen, and Wayne. Happy birthday. I mean, there are many wonderful days. Years full of them. But today is your special day. And I realize there are a million places you could be, a million people you could have celebrated with, but you chose to be here with us. The privilege, pleasure, and the honor, the joy is ours. Hopefully we can turn some of that joy back to you, make your day a little more specialer. Begin by helping yourself to free pancakes at Denny's, IHOP Village Inn, Waffle House, McDonald's, Tammy Dunlap's house, Andy's Grill, Bob Evans, and Cracker Barrel. Not a sponsor, any of them, except for maybe Tammy Dunlap. Happy birthday. That's awesome. Dancers doing their thing. Josh taking it to a new level. Alphabetical order. Oh, wow. He's a bit of an overachiever. That is amazing. Josh, thank you, my friend. Maria says, good try on the name. I've heard worse. Maria Pinheiro Karzuski. First try. Yeah, close. I know you knew I was trying at least your name. I love that it ends in Wayne. We get to take a breath at Wayne. Yeah, it was really good. I like that alphabetical thing. That was Josh. That did help a ton. Lots of free pancakes all around. All the birthday emojis. Dancers are doing their thing. We have a drum solo coming up where you get to help. Just in time for the drums. That's good. I was actually watching a drum video just before this. Here we go. Josh also comes in with a chat message saying, we have a problem. Josh says, Houston, we have a problem. We do have a problem, an audio problem on the court feed for the trial we're watching out of Judge Boyd's trial. So I think there's some we can watch, but we are just going to have to skip some testimony because Judge Boyd forgot to unmute us. I don't know how else to say this. I'm sorry, Judge. This is entirely on you. She kept us muted, and we missed a lot of testimony from a police officer. But I think we're able to get the cross-examination from the husband, which we expect to be a little bit spicy. So I think we should get some of that. So we'll go there. But before we do that, I need your help. And this might require some of you to text the burner phone and send links and things like that. Those of you who have been on the channel know that Thomas, my podcast partner, Weather Watch, is a stellar Halloween decorator. And that he has pretty much the best house on the block, or maybe even in town, when it comes to Halloween decorations. And I've never tried to compete with Thomas because, quite frankly, I could never win. It's why try when you'll always lose, right? That's where it was. I'm not competing with Thomas. My neighbors for years have encouraged me in not some nice and not some not so nice ways to participate in the neighborhood tradition of decorating for Halloween. Which has made my street the go-to destination in the county for trick-or-treating. The only place that gets more trick-or-treaters than my street, I think, is Mr. Beast's house, because he gives away Teslas and things, and so I'm right up there with Mr. Beast. Last year, we counted over 600 trick-or-treaters in one evening. It's nonstop. With this year, Halloween on a Saturday, everything, it just lines up. We're going to have more. We're going to have more. I went out. I bought Halloween candy yesterday. Please check burner. We have an issue, Amanda. Oh, no. I bought Halloween candy. Sorry, I'm getting choked up over this. I don't know why. I bought Halloween candy this year. And worried what Amanda says. I bought over 40 pounds of Halloween candy. It does cost an arm and a leg, but kids in costume, I've got to deliver. Especially, I mean, there's just a handful of houses that do this. Just a handful on this street. You could throw a rock each direction, and that's the limit of where people come to trick or treat. They just hit these houses. So it's really cool. My phone is not updating, so the internet issue might be big. Let me shut down this. Hang on a second. Amanda, I'll watch for this. Okay, so we have a lot of candy, a ton of candy. Yes, we did invest in candy. Basically, what I decided this month is instead of buying equipment for the channel, I'm investing in candy because we are going to live stream. We're going to live stream trick or treating. You'll get to see everything, like we did last year, but it's going to be a little bit bigger of production. I'm committing now to not just set up and decorate for Halloween, but set up and live stream the whole thing so you guys can watch. Because I know a lot of you don't have trick-or-treaters and you miss that and you'd like to see it. And this is a way you can do it and not have to, if you want to go to bed early, you can just be like, all right, I'm done. Click, turned off and you're done. But you get to see all the trick-or-treaters. We have some great costumes that come by. We have a lot of families, a lot of different people, just everything you can imagine. And so I want to do that. And I thought, let's see. I'm trying to see where Amanda, I'm checking the burner. I don't see anything from you yet. I don't know. Maybe it's just not coming in. I need your help with decorating. Let me tell you what our idea is. Obviously, we're going with a crime scene. I have a little bit of a budget, so we're going to get a couple things. But just initial layout, we've got, imagine our sidewalk, our house, the door is centered on our house. We have a sidewalk straight out from the door. We want everyone to stay on that sidewalk, not come on the steps of our house or anything like that. And so we will set up the candy disbursement area right there at the bottom of the steps. Each side of the sidewalk, which is a wide sidewalk, it's probably like a triple wide. It's like 10 feet wide. There's brick flower beds, brick lined flower beds. We want to keep people from tripping on that. So we're going to do crime scene tape around the entryway, like in a big U. So it comes like that. So keeps people from tripping on the bricks in the dark. I'll have some police lights, some flashing strobe lights up bouncing off my house, which is sort of a white color. So it'll on one side of the house, sort of like in the back corner. So we'll have that. All of us are going to be in Tyvek crime scene suits, like the paper suits the CSI people wear. We'll have a chalk outline, murder scene on the sidewalk where they have to walk over to get to the candy. I'll obviously have speakers and a hidden microphone set up. On the other side of my house where we have a big porch, an open area, we're going to hang a screen. I'm going to buy a projector, and we'll be showing wanted posters, which will feature the faces of the people who are coming up to get candy from us, because I'm going to take screenshots, zoom in with my camera, get their picture, and immediately have it up on the screen to show that they're the person who's wanted. So we can do that, and might put out like a bolo or something over the, all units, be on the lookout for, and so with the candy, if I can find it cheap enough, because it gets a little expensive, I'd like to give out, instead of just like handfuls of candy, because we end up giving like a lot to some and then none to others, pre-made evidence bags, little paper craft evidence bags. with candy in it. So we'll need like 500 evidence bags, and then after that we'll just give away loose candy. That's what I'm thinking. I'm thinking we'll do that. Is there anything I'm missing? Maybe some black lights that are illuminate the ground so that people glow in weird ways. Careful taking photos of minors. They're out in public. Bring it. Supreme Court. Sorry. Plus they're in costume. We won't be identifying anyone, but we probably won't put the poster, the wanted poster, on the live stream, but we'll have a live stream of everything. You can get all those supplies cheaply at Dollarama. I don't have a Dollarama. I have an Amazon. A morgue table. Ooh, that's a lot. I might need to get like some of the foam severed arm and things like that. Might see if we can find some of that. Organize an Amazon wish list. I can put it together. I just need to know what I need to get. Get the cheap brown paper sacks. Right, stop and shop. I can't write on 500 bags. I'm going to need these pre-printed. They do have pre-printed evidence bags in little sandwich craft bags. Next year you'll have 1,000 trick-or-treaters. We have, it's nonstop. It's insane. Give candy out in solo cups. They won't get the trick though. They won't understand. Black light. I'm thinking black lights to illuminate the darker areas of the sidewalk, especially where there might be some tripping hazards. Barb, I'm willing to invest in this. I'm willing to invest. We have a dollar store, but I mean, I'm getting 1,000 feet of crime scene tape. That should be enough, right? Because then I can use it to sort of decorate other areas where we don't have something around the house. Send some leaks to the burner. Because basically most of my kids are too old to trick or treat. Okay, let's see. How many pieces of candy do you give each kid? At least 3 to 4. I don't know. We have over 2,200 pieces of candy. Maybe the evidence bags might be a little too much because that's like a big bag with nothing in it. Might have to skip the evidence bags and just do handfuls of candy. Maybe we'll have a big evidence bag, like a ASMR style evidence bag that we just reach in and you can give them candy out of the evidence bag. That might work as well, like a big shopping bag. Okay. Let's see. Amanda, I don't know why. I don't know why it didn't show up. Check and see if there was anything that was sent back to you. It was like it didn't go through for some reason. It didn't show up on my end. I don't know why. All right. Evidence bags for fun party favor treat. Let's see these ones. Oh, these plastic clear ones are good. Let's see, 50 pieces for $20. Ooh. They're 9-inch by 7-inch. I'm thinking I need like a 3 by 5. Coin envelopes. I need them to say evidence on them. That's what I'm thinking. There's a 6 by 9. Strobe lights can trigger seizures. That will add to the the whole experience. The strobe lights won't be on the people directly. It will be off behind in bushes, and it will be just ambient reflecting off the side of my house. And it's not going to be like strobe. It's just going to be red and blue LEDs. Evidence stamp. I'm getting all sorts of ideas. Okay, this is what I wanted. Thank you very much. And the local police will be informed in advance. The local police will come by and get candy, probably. Let's see. Barb, thank you for gifting a membership. Emily Aarons, member for 18 months. I can't believe it's been a year and a half. Time flies when you're having fun. Bite me, Rebecca. Buttercup and I send hugs and butter sugars. We love being here. Y'all are amazing. I shortened this to y'all instead of you all are. Just did the whole apostrophe right in the middle. Thank you very much, Rebecca. Bree Roz, Halloween fun. I'll allow this. I'm a super Halloween decor enthusiast. I have to admit, this will require a huge sacrifice on my part because I'm going to have to take down my Christmas decorations before I put Halloween decorations up. I'm going to have to take down the Christmas lights. I have not done that in 2 years. But I'm going to do it. I committing to this now. The local police will be informed. They're great friends. We work with them closely. 1 year, my dad got an old pair of my brother's jeans, stuffed them, and added a bag in the top filled with red dye spaghetti. He dressed up as a zombie and was eating the spaghetti. Cheap and fun. Oh, yum. That's fun. That sounds really, really cool, Roman. That's like something I would do. Get glow-in-the-dark chalk. We were just going to do white, but use black lights, like little black floodlights on the steps, like pointed down at the sidewalk, so everyone's like costumes and shoelaces and everything will just glow. But no need to take down the lights, decorate over them. I'm going to need the same plugs, the same outlets. It is time to take down the Christmas lights. We can do a Nightmare Before Christmas theme. I like this. I like this a lot. I like where you're going with that. All right, I had to tell you this. I had to like put it out there because now I'm committed, right? I've told you this is what we're going to do. We're going to live stream Trick or Treat from the Recovery Addict household. We'll do so in a way that, keeps it nice and as safe as we possibly can. It probably will have to be a non-monetized stream, which is cool. That's fine. Just because there's a chance that someone will drive by playing music or something like that, and I just don't want to get a copyright strike or something. We'll see what we can do. Stacy sent you a link. Thank you very much. Couldn't a Christmas crime scene? Problem solved. I tell you, Christmas crime is happening right now in Sam's Club with everybody putting up like the Halloween, the 12-foot, goblin playing the fiddle in the middle of the Santa's elves and snowmen and Christmas trees. They've mixed all the displays. I don't know what holiday is anymore. Listen, Chris says, Halloween fun train. Let's keep it going. We love this community. I'm good. I've got the budget. I've got the budget for this. I'm just not going to buy any equipment this month. That's my plan. So I'm covered here. I'm not asking for funds for Halloween. It's the candy's paid for. $214 for the record of candy. It's a lot of candy, but we just won't get any new gear today and this month, and we'll be fine. Writing down these suggestions. I've got them actually in the Amazon wish list. I've been putting some in. Have your kids dress as cops. Do dress as detective. Put cheap little magnifying glass in the evidence bags. Great ideas. Great ideas. Okay, this helps. I'm going to go through some of these as well because there's. Let's see. We will share. We will share. We'll share everything. All right, that's it. Let's get going to court. That's what we came for. Apologize. We've been sort of talking about me things instead. We have to go back to Judge Stephanie Boyd. My eyes are getting so bad. There she is. Nope, that's Thurston County. Judge Stephanie Boyd. Yesterday. It was before this. Trying to find where we were. Not there. I think it was this one. Amanda H., it worked. The membership showed up. Thank you very much for the gifted memberships. Rick, Katz, Serafina, Annie Marie, Sanabelle, and Kimberly, all the recipients. Thank you very much for the generous gift on your birthday. On your birthday. Happy birthday tomorrow to my youngest grandbaby, 6 years old, Lydia Ross. Janet, Lydia's going to be 6 tomorrow, going on 16. That's how it is. Love you, baby girl. That is awesome, Janet. Happy birthday to Lydia Ross tomorrow. Maybe Mrs. R.A. can dress up as a coroner. I think we're all just going to do the painter suits from Lowe's, like the crime scene, the paper Tyvek suits, because they're fairly cheap. I think that's the idea. And they also show up really well under black light. They really pop. So you having up Christmas lights is like the same amount of time Farag was on the run. Basically, when he went on the run, I stopped taking down my Christmas lights, which was, I realized, in September, and I still had them up. But yeah, that's it. Fog machine? Oh, I do like fog machines. I've got a lot of area to cover. And I would need like an industrial strength fogger, and I would blow my entire budget on that fogger. It would be like a $700 fogger to fill up the yard like I'd like. All right. Can you splash neon paint on them and handprints? I was going to do possibly some like bloody footprints type thing, but I'd like them to show up under black light. So if you guys know of a paint that looks like blood, but also shows up under black light, that would be great. Dry ice and water equals fog. Yeah, just not the volume I need, and it goes to, I need like 6 hours of it. Plus, I get too, when I get around dry ice, I get too tempted to create small poppy noises with closed packages. It's really dark. Put a few crock pot boxes around. This must be super dark. I missed it. Crock pot boxes. This is like super dark. I have no idea what that means. It flew over my head. Neon paint will work. Can't believe the judge released Mr. Farag yesterday. That was a huge shock considering he was on the run for almost 2 years. Rent a white panel van and park it in the yard with a table outside of it with your evidence on it. Use electrical tape to write forensics lab on the van. I pretty much have a white vehicle that I could park there. Not taking down your Christmas lights is a crime. I'm going to take them down. It's just I was slow to do it. You can add reactive powder to make it glow. That's what I'm looking for, reactive powder. Somebody text me that if you find it on Amazon. All right, I think where we are, let me see where we are. I think we had just taken a break with the dad on the, or the husband on the stand. And we're just waiting for him, waiting for everybody to come back. Hang on. Okay, here we go. We're going to begin where we left off. And there's a point on here where the audio goes bad and you just can't hear anything. I'll do everything I can to make it work, but it is what it is. So,
all right. Any objection to the accused family remaining in the courtroom? They're not being called for this phase of the trial.
No objection, Your Honor.
Oh no! I know you don't have any objection.
I'm glad he doesn't have an objection.
Yeah.
So long as he's not testifying during guilt and innocence, I have no objection with him remaining in the courtroom.
Judge, yeah, they're not a fact witness. They basically guilt innocence space. We're not going to call them.
All right, let's bring the jurors back in.
All right, for the jury.
Kelly, thank you so much. Appreciate that.
Oh, and just so y'all know, you can sit anywhere. There are no assigned seatings.
It looks like they're going.
All right, everyone, please be seated. All right, state you've concluded your direct examination.
Yes, correct. Your State will pass the witness.
All right, defense, you may proceed.
Thank you, Your Honor. Hi, Mr. Rodriguez. My name is Amy Owen, and I represent Shelby Rodriguez.
That's right.
If there's any question that I ask you that isn't clear or you need me to repeat it, just let me know, okay? And would you mind moving the mic closer so I can hear you a little
Like
bit better?
this?
Thank you.
You have to turn your mic on too.
I'll do what I can with the audio here.
Okay, so you have 3 daughters, correct?
Yes, ma'am.
Shelby was a stay-at-home mom, correct?
Yes.
Did she homeschool them?
She attempted to homeschool them.
Okay, but she was homeschooling the kids for this incident, right?
Jenna, yes, she was the school-age child.
Okay. And did you work outside the home or inside the home?
I worked at home.
You work from home?
Yes.
Okay. Let's talk about the slap. When did you slap Shelby?
That was during the start of COVID.
Okay. What happened?
Mid-COVID. She was making big over the facts. I don't remember exact dates, but she was making masks for people, complaining that whenever she was mailing them out, they weren't wearing them, etc., and neglecting essentially everything else, the children, etc., like everything.
Okay, so you slapped her because of that?
No, she had slammed a door, and she had slammed a door whenever, and was we were in an argument, and she was yelling at me and slammed the door. That's why I can't recall like exact details. It was 2020-ish. It was a long time ago.
And was that the only time you've ever been physically abusive to her?
Yes, ma'am.
Okay.
That's the only time I've ever laid any sort of hand on her.
Okay. So you go to Florida and you cheat on Shelby, right?
Yes, ma'am. I went to Florida and I cheated on her once. Yes.
Okay. And isn't it true that you started telling Shelby that you thought you might have an STD?
I told her that I was feeling lethargic, that I was itching, that I was feeling terrible. And so, yes, I did tell her like those are the symptoms that I was feeling.
Okay. And so you didn't actually just come back and confess that you had cheated on her. You actually were feeling some sort of, I guess, discomfort, or like that you thought you had an STD.
Yeah, I was feeling terrible. I was trying to find a way to bring it up. Like the guilt was eating away at me.
Okay. And so it's true, isn't it true that Shelby had to go get all sorts of medications and things to make sure she didn't have an STD too?
Whenever you go to the doctors and you tell them you're suspected of having something, they prescribe the medications. The same ones were prescribed to me, even though both tests came back negative.
Okay. And so this confession happens on October 30th, the day before Halloween, right?
No, ma'am. It was on the morning of October 31st.
And so the kids go to your
It was on
parents.
Halloween.
Yes.
And you then go on this trip together a couple days later with the kids?
Yes, the Boy Scout trip with the kids.
Okay.
It was that weekend.
I'm sorry?
Oh, it was that weekend, the
Okay.
4th and 5th, the morning of the 4th and 5th.
Going back to whenever you said she called the crisis hotline,
Yes,
you
ma'am.
said you were listening in on the call. How?
I had woken up because she asked me to sleep next to her on the daybed. So whenever I woke up, she was on a phone call, and I was just listening as she described how she was. I don't remember the exact verbiage. It was something to the effect of, she was having a breakdown. She wanted to beat me over and over with a skillet. I can't remember every single detail as to the call, but essentially that was the gist of it. It was
And sir,
early in the morning.
I didn't mean to interrupt you. You're a software engineer,
Yes, currently that's my current role at Precisely.
and what's your education background?
I went to Trinity for my bachelor's and then UNCG for the master's online program.
Okay, so you have a master's degree.
Yes, ma'am.
So Shelby is on a crisis hotline
Mhm.
talking about beating you to death with a skillet and killing the kids or having a bloodbath, right? That's what you testified
It
to?
wasn't it wasn't the exact same incident as far as I know. The bloodbath and the kids were after I came back, the crisis hotline, skillet. Yes.
Okay, so it's fair to say you're a pretty well educated man, right?
Don't know, I guess.
Okay.
He doesn't know if he's
did
educated.
you ever think, let me get my wife who's in crisis some help and take her to a mental health hospital or do a 3-day hold on her to see if she's okay?
No, you can't force someone to do anything like that. She's brought up needing help before. She's has the logins to all the health providers. As far as I'm aware, I can't force anybody to get help.
Okay, so did you reach out to any crisis hotlines or any mental health professionals on her behalf to see if you could get her some help during this time?
No.
And then, so you basically just are sort of there, but you're not helping her in any way, right?
I'm helping for whatever she asks me to do, whatever she asks for help with. I don't want to exacerbate and I don't want to interject or imply or set her off by saying she needs help or else give ultimatums, because that would just lead to an even worse situation.
Okay, so you said that she was beating you with her hands. You said closed fists and open fists, or hand and closed fist and a broom, right?
Yes.
But you see those pictures. You don't have any injuries on your body, do you?
I had some bruises show up a little bit later. They weren't immediate.
Okay, but you would agree with me that the pictures don't show any redness or contusions or swollen. Your face isn't swollen. There's no scratches, anything like that.
I don't know. You saw the same pictures. There wasn't any like serious swelling or scratches that I saw.
Okay. So
I don't know what a contusion looks like. I'm sorry.
So she's in the kitchen and you remember you're around the island area of the kitchen, right?
Yes, ma'am.
This all happens like around 2:30, is that correct?
About 3, I want to say it started. So it's 2:30 to 3. In between there was unpacking the car.
At some point, I mean, y'all even order pizza, right? For the kids?
No, I never ordered pizza.
You didn't get a pizza off your front porch?
Me? I don't remember getting a pizza off the front porch. If I did, I'm sorry, I don't recall if I did, but no, I don't remember getting a pizza off the front porch.
That's a good soundbite.
And so then
front porch pizza,
you start
anybody?
packing your things, right? And you're packing the car while she's beating you all around the house with the broom and her fists.
Okay.
And at one point, you tell the officer that she's following you around with a knife. Do you remember that?
I don't. This was 2.5 years ago. I don't. If I told the officer that, I don't remember it right now. Or
Okay.
2 years ago. Sorry, not 2.5 years ago.
Was
2
she
years
following you around with a knife?
I don't remember.
Okay. And then you say that she points the knife at you, right? Or in a downward motion.
Yes.
And then she puts the knife to her own throat.
Yes.
And isn't it true that you lunged at her and pushed it into her throat?
No.
Okay. And then she reaches for the gun, right?
Yes.
And you say that she holds the knife to her throat, right? She ever put the gun to her head?
I don't remember if she did.
Okay. And so the knife is pulled on you, the gun is pulled on you. I mean, at what point do you grab your 3 little girls and go call 911 and say, my wife is a homicidal maniac right now? Come help me.
I didn't. She told me I can't take the kids. She had the gun pointed at me. The kids were going in and out of the house. I know whenever she had the broom and was beating me, I'd seen them around the daybed. But if she threatened me with calling the cops, and she's going to say that I beat her and this is what she had to respond with, I felt helpless. I didn't know what to do. The kids are there and I don't know what to do that won't make the situation worse.
But you had your cell phone, right?
Did I have my cell phone? Yes, I had my cell phone.
Okay. You called your family.
After I had left the house.
Okay, let's get to that. So
Yes.
This incident just occurs and you leave the house and leave at that time they were what?
6, 4, and 4.
A 6-year-old and 2 4-year-olds with Shelby, who has just pulled a knife and a gun on you.
And threatened to kill the whole family,
hours.
apparently.
For however long. Yes, I was in the car whenever I called the family asking if I could stay, and I kept saying I don't know what to do. Like, I did not know what to do.
Leaves his kids, grabs his laptop, goes to Chuck E. Cheese, doesn't call 911. His wife is allegedly threatened to kill herself, the kids, and him.
To Chuck E. Cheese to get a replacement bubblegum machine during this time?
Yes, I drove over there because I wanted to replace Kira's machine. I thought it would give me some time to think, and the whole time I'm thinking, what do I do? Maybe if I drop off the gumball machine, she'll calm down. I'm not sure.
Sounds like he broke the gumball machine.
What exactly, can be done to keep a calm situation. When she locked me out of the house prior, she had locked the garage doors, the front doors, all the windows, everything. There would be no way to get inside, even the deadbolts, without breaking a window or something. And if she locked down the house and in any way, shape, or form, the situation were made worse, something happened. I didn't know what would trigger her to harm the kids and herself.
So you thought in that moment, the best thing to do would be to leave the kids with her and take off to Chuck E. Cheese, Walgreens, and the park at your neighborhood.
No.
But that's what you did.
That is what I did, because I was called and told to stay in the vicinity, that 911 had been notified, and I was participating with whatever, cooperating with whatever the officers wanted and whatever the operator had wanted at that point in time. I didn't know what to do that would keep everybody safe in that situation. I'd never had a gun pulled on me before with the clip inside and pointed at my head and somebody saying that they could fucking kill me. That's not the kind of life.
You would agree with me that the normal thing, if someone did that to someone, is to call 911.
Objection, Your Honor. Speculation.
Overruled.
Would you agree with me that if someone did threaten to kill you with a gun and a knife, most people would call the police,
breathing.
Say, help me?
I don't know. I don't know what most people would do. I would assume they would whenever they were at a safe distance if
Like
they didn't
Chuck E.
have someone
Cheese.
else to worry about. If it was just Shelby, absolutely. But she's at the house with the kids, with the house on lockdown. I didn't know if the cop showed up, if she would say it's over. I did not know what was going to happen. And I was in shock.
What do you mean what are you talking about when you say the house is on lockdown?
I mean that the doors are locked. We have a Ring camera. If it had caught the officer, I didn't know what potentially would set her off.
Isn't it true that your AC was out, so every window in your house was open?
No.
So,
The downstairs AC was low on Freon and did run out. The upstairs one was working fine. It's a dual unit. And I would not say that every single window in the house was open. I don't recall if they were or weren't, but I don't know why they would have been. It would have just let the cold air from one of the units out.
okay.
I'm having a hard time believing him.
One moment, Your Honor.
Chuck E. Cheese. I thought that if I went and
Was there ever a struggle for the firearm?
No.
Again?
No.
Do you recall telling one of the officers that you were down on your knees when she pointed the gun at your head?
Yes, at one point I do recall that I told the officer I was down on my knees, and I did go to my knees, and then I stood up and I just asked her again, just kept saying, please don't shoot me in front of the kids. It's the last thing I want is for them to see their dad get shot.
And can I please take my laptop and leave the kids here? I'm struggling here. I'm struggling. Him saying, me going to Chuck E. Cheese, if I just got a replacement gumball machine for one she just smashed, then that would appease her? That would calm her down? Yeah, I get the feel that he's not telling us who actually smashed the gumball machine.
Testified on direct that Shelby got the gumball machine and smashed it on the floor, right?
Yes.
That's the first time you've ever told anyone that, isn't it?
I don't believe so. I don't know when I had mentioned it, but I don't believe it's the first time I had said it. I haven't. It could have been any of the interviews, or it could have been to the officer who took the statement at the park, or at some point in time, the affidavit. I don't know when. But
did you ever pull Shelby down the stairs of your house?
Pull her down the stairs? No.
Shelby glanced up and glares at him, direct eye contact after he says no.
Pass the witness.
Briefly, Your Honor, if I may.
Yes.
Thank you. Now, you described that the house was on lockdown, correct?
That's the best way I can think of describing it, as in there was no entry without breaking something to get in, would be the best way to describe it.
Why was that?
Why was that?
Did Shelby tell you to not come back? Or
Yes, he told me not to come back.
Just 1 second. When an objection is raised, you need to stop talking.
Yes, ma'am.
And then I will make a ruling. And if you don't understand my ruling, you can just look to me and ask me whether or not you can answer the question or not. The objection will be sustained.
Okay. To your knowledge, why was the doors locked and the windows locked and the house, as you say, on lockdown?
She told me not to come back, that she didn't know what she was going to do. If she saw me, she was going to call the cops on me. And that previously, whenever she had said that, and everything would be locked, the windows, the doors, etc.
And when did she tell you this?
She told me that on November 5th, 2023.
Well, okay, yes, you're right. Did she tell you this at any point while you were in the house, or did she tell you this
Whenever I was
outside
in the house.
Okay, at what
And
point when you were in the house did she tell you this?
after I agreed to leave and as I left, she reiterated it that I can recall. She may have mentioned it other times, I don't remember.
Okay. So to the best of your knowledge, like you're testifying, as you're leaving the house, after you had your necessary things for work and clothes, etc., packed, is when she iterates this to you. Is that correct?
Can you repeat the question?
Yes, I can. I'm sorry if that was confusing. As you're leaving the house, after all this has happened, with the items that you packed up, to the best of your knowledge, would that potentially have been when she had given you that?
Yes, she would have. She
Okay.
reiterated then, yes.
Okay, she reiterated it to you potentially at that point?
Yes.
Okay. So you took that to mean what?
I took that to mean that if she had seen me by the house, if she had seen any police officers or anything out of the ordinary, that she would harm kids herself or call the cops on me or I didn't know what was going to happen. I didn't know what, just it wouldn't have been something good.
Did you feel welcome to return after you had left?
No.
And why not?
Because she had said if I did return that she was going to call the cops and say that I beat her.
Okay.
That's what he was afraid of. Don't.
You were asked on cross-examination about the
cops
gun.
don't believe her.
Yes.
To your knowledge, and if we can go into a little bit of detail about this, how did that gun first end up in your house?
She had purchased it as a Mother's Day present to herself.
Okay.
First time.
To your knowledge, when Shelby did that, how did she store the gun in the house?
I don't know where it was kept at every point in time. I just know at that point in time it was above the fridge with the clip in it and another loaded clip by the side.
And how do you know that the clip was in the gun and the other one was by its side?
I saw that the clip was in the gun when she pulled it out of the cabinet and pointed it at me. Okay. And then the clip by its side I'd seen up there prior.
Okay. To your knowledge, did Shelby regularly keep the gun loaded?
Yes.
Okay. Did you at any point in time feel like the gun was unloaded?
No.
Okay. So
loaded as in has a clip in it, then
loaded as in has bullets in the clip in the gun, and
yes,
accessible to her.
Yes.
Okay. So when she pulled it out, is that how you felt, that she was pointing a loaded gun at you?
Yes.
Okay. At any point in time after she pointed the gun at your head and made that threat, did you ever touch that gun?
No.
Have you ever touched that gun since this has happened?
No.
At any point in time while that gun was in your house, did you ever touch the gun?
I can't recall. I don't know if I ever touched it while I was in the house.
Does anything stand out in your head that would lead you to believe that you had at some point touched the gun?
Whenever she would have showed it off as, for Mother's Day, when it was purchased.
Okay.
That would have been a good reason to touch it and see how to load it and so forth.
Okay. Approach the witness, Your Honor.
Yes.
Rodriguez, I'm handing you what has been pre-marked for identification purposes as State's Exhibit 35.
Okay.
Do you recognize what I'm handing to you?
Yes, you're handing me the purple knife.
Well, what is it first?
What's that?
What is this
Oh.
first?
This is the picture.
Okay, what is on this picture?
A tape measure, the knife, and the sheath to the knife.
Do you recognize?
And the gun case. It's on top of the gun case.
Okay. Does anything stand out to you about what
Yes.
is on the picture?
The length of the knife blade.
Okay. Does anything stand out to you about the knife specifically?
It's a kitchen knife. Cuisinart. Oh.
See
Cuisinart,
anything
not a
on the
sponsor.
knife? Any discolorations? Anything that's
Yes, there's a slight discoloration on it.
Okay.
In the middle.
Do you know how that got there?
No.
You testified earlier that when Shelby was waving a knife at you, that you never touched the gun. Is that the knife? Is that correct?
Yes, I didn't touch her, the knife, or the gun the entire time. I didn't.
After the incident was over, did you ever touch the knife?
No.
Have you ever touched the knife since this incident has happened?
No.
To your knowledge, is this a fair and accurate representation of the knife as it appeared the day of the incident?
To my knowledge, yes.
To your knowledge, has the knife that's in this photograph been altered in any way?
Not that I can tell.
Thank you. Mr. Rodriguez, at this time, please will offer evidence exhibit 35 and will turn it to defense for any objection.
Okay, so her fingerprints are going to need to be on the knife and the gun. Let me just say this. I am detecting in him a very, it might be a character trait, a very literal response to questions. That is a picture. That is a, when did you tell me? On this date. He processes questions differently, but I think that is his style. So we have to give him a little space and grace as he's answering a little differently than.
All right, State's Exhibit number 35 is admitted without objection.
May I publish to the jury, Your Honor?
Yes.
It's an engineer trait. Possibly neurospicy. Could be. Would that explain my wife threatened to kill the kids, so I went to Chuck E. Cheese to get a
Mr. Rodriguez, I'm putting on the screen what has now been entered into evidence, State's Exhibit 35.
Okay.
You had testified that you noticed a discoloration on the knife. Is that correct?
Yes, from the picture you're showing me, yes.
Okay. Can you tell me where on this picture you were seeing that?
It looks like the middle of the blade around the 9-inch mark from the handle.
9-inch mark, should that be right around here?
Yes.
What do you see right around here?
I see a discoloration on the knife blade.
Do you have any idea what this might be?
Just, all right, that objection will be sustained.
Speculation. Are they trying to say that there's blood on the knife?
To your knowledge, did you do anything to cause this discoloration on the knife?
No.
Was it tested?
You were asked on cross-examination about Shelby's mental health and getting her help.
Yeah.
Would you ever force Shelby to do anything she didn't want to do?
No.
Did you feel at that time that you could force her to seek mental health help?
I don't believe so. I don't know how you would force anyone to seek mental health help.
Did you ever have a discussion with her about getting help for her mental health?
We did in the past. I couldn't tell you exactly when and where. And at that point in time, yes. But again, I wouldn't know specifics about it.
You were asked on cross-examination about the injuries that you sustained and how in the photographs, they're not showing anything that's really noticeable that stands out, like contusions, like defense was saying, bruising, etc. Did you develop injuries on your body later on?
I did. I had a picture taken of my shoulder afterwards that I remember the officers didn't take. I believe I don't remember who took it, but there was definitely some bruising that had showed up.
Okay. Bruising, did anything else show up other than bruising on your body?
Not that I can recall.
And to the best of your knowledge, how did you get those bruises that developed later on your body?
It had to be from being hit during the incident.
Did you do any other type of physical activity that would have resulted in bruising appearing on your body?
No.
Okay. How soon after this particular incident happened did you notice those bruises developing on your body?
I can't recall. It was within the week.
Okay.
It would have been a day or two.
Okay. So would it be fair to say shortly after?
Yes, shortly after.
Okay. Other than the one time that you testified to slapping Shelby, have you ever been physical toward Shelby?
No.
Okay. Even though the pictures that we talked about didn't show at that time the specific injuries, were you still threatened with a knife by Shelby?
Even though the pictures did not show, I'm sorry, are you asking if I was threatened with a knife by Shelby?
Even though the pictures do not show physical injury that much.
Yes, I was threatened with a knife by Shelby.
Did you still have a gun pointed at your head?
Yes.
Did Shelby threaten you with that gun pointed at your head?
Yes.
You testified about the children may have seen some of this. Do you recall what, if any, they may have seen?
I don't.
Okay.
The back door to the patio and the yard was unlocked. They could roam in and out at will. I don't.
Okay. When, after you left the kitchen area where the threats with the knife and the gun were made, when was the next time you recall seeing the children?
Whenever I was carrying stuff downstairs from upstairs, the little Father's Day trinkets, they had made me and some pictures of them. I'd seen them on the daybed.
Okay. And you left without the children, correct?
Yes.
And why was that again?
Because she did not want me to take the children. She said she would call the cops and say that I had beat her and threatened her if I tried to take the children or if I came back or if I did anything.
And because of that, would you have taken the children anyway?
Because of that, would I have taken the children anyway?
Correct.
No, because I didn't. If she tells the cops I beat her and I get thrown in jail, I don't know what's going to happen.
Why would they believe her if she tells them that?
Other than this one day, had you ever been locked out of the house before by Shelby?
Yes.
How many times would you say that Shelby locked you out of the house?
I don't know the exact number. The only prior time that I can recall with absolute certainty is the 31st of October.
Well, let me ask it to you this way. To your best of your knowledge, has Shelby locked you out of the house on more than one occasion?
I don't remember.
Okay. Was there another incident besides this one and October 31st that where Shelby locked you out of the house?
Objection, Your Honor, may we approach?
Yes.
This seems, I don't know. I'm struggling. I see this and I don't know. I don't know what to think. Could just be awkward and not well spoken. Apparently all the doors only unlock from the inside. kid with a cough.
All right. State, are you proceeding with the question or withdrawing the question?
Officially, I withdraw the question. May I have a brief moment, Your Honor?
Yes.
While this is getting set up again, I'm sorry, it takes usually a second or two once you close and open it. You had testified earlier about how while Shelby was hitting you with the broom, at one point you grabbed the handle and that it became disconnected from the bottom where the bristles are, correct?
Yes.
Okay.
So
I'm going to put up State's Exhibit 22 again. And this, you testified earlier that this is the broom that she used, correct?
Yes.
Okay, now this picture shows the broom intact. Do you know how the broom came back to being intact after you had taken it apart when you grabbed the handle?
You repaired it.
No, I'd assume that she put the stick back inside the handle.
Okay, so to the best of your knowledge, you didn't put the broom back together, is that correct? Okay.
She built a broom. From, she's probably been to the Build-A-Broom website. That's what you do. Yeah, at one point he had the part that will
May I
hurt
have another
you.
brief minute, Your Honor?
Yes.
Thank you.
Judge Boyd asks them to remain seated. We've seen this, I think, a lot in Texas, actually. It's common to see lawyers stand, but the judge is like, stay away from my desk. You stay over there. I don't want your germs up here. It's a judge's preference.
All right, State, you may ask your next question.
This time, Your Honor, State will pass the witness.
When slapped Shelby at the beginning of COVID, did she call the police on you then?
No. She had called my sister, and my sister offered to call the police on me, the same one that called 911, and Shelby said it wasn't a big deal, just her pride was hurt.
Would it surprise you that when the cops arrive, Shelby never tells the cops that you beat her?
Would it surprise me when the cops arrive that Shelby tells the cops I never beat her? No, it wouldn't surprise me because I never beat her.
Right, but you said that she kept threatening you with if you take the kids or if you do this, she's going to call the cops and say that you beat her, right?
Yes.
Because you did beat her that day.
I did not beat her that day.
That's the way.
I didn't beat her at all. Like, I don't understand sorry, what's the question? I'm like,
Mr. Rodriguez, she passed.
Sorry, go for it.
You don't have to go anymore, and State has no further questions, Your Honor.
All right. You may step down. Is this witness subject for recall?
Yes.
Yes, by the State, and
All right. You need to make sure you're available if either side wishes to recall you. The rule has been invoked. That means that you're not allowed to discuss your testimony with anyone until this case has concluded. Do you understand?
Yes, ma'am.
All right. You may step down. State, call your next witness.
Your Honor, at this time, State calls Officer Hernandez.
Okay, we're going to lose audio at some point during this, and we're just going to have to skip ahead. Might just jump to closing arguments. So, should we jump to her?
No, just leave.
All right. If you could raise your right hand. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right. You can lower your hand. Make sure you keep your voice up so everyone can hear. If you'll state your name for the record, please.
Jordan Hernandez.
All right. State, you may proceed.
Apologies, Your Honor. Let me get that a little.
I think we need to jump to her.
Good afternoon, Officer Hernandez.
Okay, hang on one second. We're going to jump to her testimony. Who's this guy?
And can you raise your right hand? Do you solemnly swear affirming the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand. You can adjust the microphone. Please make sure to keep your voice up so everyone can hear. If you'll state your name for the record.
Yes, my name is Justin Carrion or Carrion.
All right, is everyone able to hear?
Yes.
All right, you may proceed.
Thank you, Your Honor. Detective, how are you currently employed?
So I am employed with the San Antonio Police Department as a detective within the Special Victims Unit.
Okay. How long have you been employed with the San Antonio Police Department?
I've been employed 12 years in total.
What is your current position with San Antonio Police Department?
So currently I am a detective with the Special Victims Unit, and I am stationed right now at the Family Justice Center, mostly focusing on protective orders now.
Okay. Could you please explain to the jury what some of your normal duty responsibilities would be as an SVU detective?
So we get assigned cases to investigate that are that involve family violence. So my role within there was specifically family violence.
When you say family violence, what type of cases do you investigate specifically?
So there would be felony versions. So you would have the enhanced assault, so assault family seconds. We also deal with the enhanced protective order cases, injury to child, strangulations, just various, and most of them are various forms of assault cases.
Okay. Now, can you please explain to the jury what specifically you had to do to become a detective with SAPD?
So to become a detective with San Antonio Police Department, there is a 5-year central wait period. You have to do that time as a patrol officer. And then after that, you get to take an exam, a promotional exam. That exam, 100 questions under various topics, including the state laws, obviously the laws that we use, our policies, and other procedures as well. And basically, whoever does the best on that exam, whatever spots are open, they start taking those spots.
Okay. Now, you testified earlier that you primarily would investigate family violence cases, mainly involving assaults, correct?
That's correct.
Over the course of your career as a detective in the SVU unit, how many cases would you say you investigated related specifically to that type of matter?
So as of now, I mean, I would be at approximately, I want to say it's about 1,000 cases so far.
Okay. Could you please explain to the jury how cases go about getting assigned to detectives in the SVU unit?
Yes. So there are two general ways that they come in. One could be what we consider a hot case, which would be the officers have responded to a scene, an active call, normally an assault for the type of cases that I would deal with. They have both parties there. They determine that this needs a detective based on our policies, and then they would call that into the Special Victims Unit. So then we would get assigned that case to handle right then and there. Another way would be is if there was no, if an officer went to a scene and it was just for a report and no immediate danger is assumed to be following right after that, that case would get written up and then it goes to our supervisors who then assign it to us to handle on a, I guess you could say, a slower basis on that point.
Okay.
I think we're going to skip
Now,
to
in
testimony.
either instance, whether it's the hot case that you described or just the case that your supervisor assigned to you, what are the normal procedures in place once you know?
We're going to skip to her testimony. I'm sorry. Here we go. We need the other side before closing arguments, which is going to start in a little bit. Thanks, mods. I know I'm throwing you around with how we jump here, but
All right, everyone, please be seated. The state has rested. Defense, you may call your witness.
Your Honor, this time the defense called Shelby Jean Rodriguez.
All right, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand. Make sure that you keep your voice up, and there's a silver microphone that's on the table, little square microphone. If you'll put that somewhere in your lapel, it's so that the court reporter can hear.
Okay.
All right, and if you could just say something to see if everyone can hear.
Good evening.
All right, is everyone able to hear? All right, defense, you may proceed.
Good afternoon, ma'am. Would you start by introducing yourself to the jury?
My name is Shelby Rodriguez.
Shelby, how old are you, ma'am?
I'm 41 years old.
Do you know an Anthony Rodriguez?
Yes,
How do you know Anthony Rodriguez?
he's my husband.
Want to start kind of at the very beginning. If you remember, when and where did you and Anthony Rodriguez first meet?
We met at a 80s club called Numbers in Houston.
Do you remember which year it was?
It was September 2nd, 2006.
Okay. Did y'all start after you first met? Did you start dating shortly thereafter?
Yes.
Okay. How long did you and Anthony date?
Oh, it seemed like forever. It's like 2 days after we met, we never separated.
And at some point, did you move to San Antonio, Texas?
Yes, we moved to San Antonio, Texas in 2018 whenever I was pregnant with twins.
What brought you to San Antonio?
His family.
To be closer to their family?
Yes,
His family?
yes, they're retired military, so they wanted us to be here so they could be close to our children.
Okay. And I think the answer is, how many kids do you and Anthony have together?
We have 3 beautiful girls.
What are their names and ages?
We have Jenna, she's age 8, and then we have Kira and Veronica. They're fraternal twins, and they're 6.
So I want to start talking and getting closer to 2023. You remember there's an incident on November. Do you remember an incident occurring on November 5th, 2023?
Yes.
Sorry, beg money. Give me a second. Okay, my apologies. Shelby, how would you describe your marital relationship to Anthony around the time of November 5th, 2023?
We were disconnected. In July, whenever he made a new friend, I had noticed that he was pulling away from me because they were frequently bar hopping. And
we'll go kind of one by one. You said you're talking July, so the summer beforehand?
No, it was, so the incident happened in November, so it was the summer before the fall. So yeah, July 2023, sorry.
No, not a problem. Are you a bit nervous?
Yes.
Okay. Let me ask you, you ever testified before?
No, I haven't.
Is it, okay. And if you need me to repeat or slow down or rephrase the question, just let me know, okay?
Okay.
You talked about in July of 2023, you said Anthony made a new friend?
He was his work associate.
Did you know this person?
He came over to the house once.
All right. So was it him?
Yes.
And you said about this time y'all were distance was building between the two of you?
Yes, his business colleague was going through a breakup with his wife because he was having extramarital affairs. And
getting closer to the incident, I think we heard that, well, October of 2023, what were y'all doing that day?
It was early morning, around 1 a.m., and I was washing dishes, and Anthony woke up and said that he had a burning sensation in his groin area.
And did you say that this happened in the morning?
Yes, it was early morning on Halloween. So it was October 30th at midnight, and then it was 1 a.m. on October 31st, but the morning of.
What happened next?
I made a dark joke.
What did you say?
I said, "Oh, well, I hope it's not syphilis."
Did you suspect it was syphilis or anything at the time?
No, it was 1 o'clock in the morning. I was tired. I'd been up with the kids all day, and I was just washing dishes, and he was saying, "Oh, I'm burning," and he had been having migraines and things like that. And so I was just like, okay, that's.
At some point, did Anthony go to the doctor?
After I went to the doctor.
So we'll start there. When did you go to the doctor?
I went and sat at a ER clinic from 5 o'clock in the morning until 8 a.m. when they would see me.
And what day was this?
This was October 31st.
What made you go to the doctor that day?
Whenever I was washing dishes, he was beside me on his phone, and whenever I made that joke, he started Googling symptoms of syphilis.
Did that cause you concern?
Yes, because it meant there was infidelity.
Did you receive any kind of treatment or prophylactics, lack of a better word, from the doctor?
I had a shot in my bottom, and they gave me some pills.
Is it correct to say that the shot was administered at the clinic by a doctor or a nurse?
Yes.
Okay. And you said it was in your buttocks or hip?
Mm-hmm.
And then they gave you, I guess, pills to take home with you?
Yes.
Okay. Did you ever receive a shot in your arm?
No.
So you said that was October 31st. Is that correct?
Correct.
Between October 31st and November 5th, did your family take any kind of trips?
Yes, we went to the Mays Family Ranch for a Cub Scouts trip.
And where is the Mays Ranch at?
I wasn't aware. I was wrapped up in packing and everything, so I just followed.
Okay. Is it in San Antonio area?
I think it's a little south.
I don't know. What day did you return from the Mays Family Ranch?
November 5th.
November 5th. If you recall, what time did you return to your house on November 5th?
It was probably around like 12:40, 1 o'clock.
12:40 or 1?
Yeah, like right around in there.
12:40, 1 o'clock.
Were you, Anthony, and the kids traveling together, or were you in separate cars?
We were in separate cars.
Why were you in separate cars?
Because we were taking turns going home and letting the dogs out. We had a husky who was a puppy, and I felt like it would be cruel to make her wait. So I insisted that we go home and let her out.
Don't you have a corgi too?
So there was is it safe to say then, or correct to say, that one of you would take a trip from the Mays Ranch back home to tend to the dog and then return back to the ranch?
Yes.
Shelby, talking on November 5th, 2023, was there an altercation between you and Anthony Rodriguez?
Yes.
I want to start taking where did this altercation take place?
It took place in the kitchen.
The kitchen? Your Honor, may I approach?
Yes.
Yeah. Somebody's already been admitted.
I'm whispering right into the microphone for effect.
You want to just use the one
He wants to look through them.
Okay. Yeah. All right. I believe it.
Your Honor, may I approach?
Yes.
Thank you. Ma'am, I'm going to show you some photographs. I want you to look at them, but don't show them to the jury just yet, okay?
Okay.
You can show them to us, though.
Would you take a look at these photographs, please?
Okay.
You recognize, do you recognize these photographs?
Yes,
And what are these photographs in general showing?
that's my kitchen after our AC went out.
Are these a fair and accurate representation of your kitchen, of your house, on November 5th?
Yes.
Your Honor, we move these as defense exhibits 3 onward, pending any objection from the state. Yeah, which I'll get into a little bit later.
I'm looking for Halloween stuff. You guys sent me lots of links, so I'm exploring them all.
No objection from the state.
All right, and what exhibit numbers are they?
Yes, Your Honor. I believe we have defense exhibits 1 and 2. These will be marked 3 through defense exhibits 3 through 10.
All right. Defense exhibits 3 through 10 are admitted without objection.
Your Honor, I'm going to mark them right now.
Looking for a good body bag. I'm pretty much, my search history right now is very incriminating.
All right. Ms. Rodriguez, Shelby, I want you to take a look. I think you said that you recognize all these photos and that they are from the interior of your home. Is that correct?
Yes, that's correct.
Okay. Taking a look at what's been marked as Defense Exhibit 3. What are we looking at here?
This is a picture of the middle of our kitchen. It's our kitchen island.
Okay. And on this, you see a Capri Sun box, some miscellaneous items on there. Is that correct?
Yes.
Do you see a pizza box on there?
Yes.
And where did the pizza box come from?
Grimaldi's.
Grimaldi's, not a sponsor.
How did it get to your house?
From Aldi's.
I placed an order for it, and then Mr. Rodriguez brought it in along with the sodas.
Okay. In this photo, do you see a fan?
Yes.
And whereabouts on the picture do you see the fan?
The fan is in front of my oven, and it's my oven and my microwave.
Why is the fan there?
Because our AC is out, and also because I had swept and mopped the floor after the incident.
Okay. So after the incident between you and Anthony, this fan was plugged in?
Yes.
Okay. Your Honor, may I publish this to the jury?
Yes.
Ma'am, we're looking at defense exhibits number 4 here. What is portrayed in this photo?
In this photo, you can see our island, you can see our fridge, you can see the mop that I was mopping with, you can see the vacuum, and
just another angle of the kitchen. Sorry. Going on to number 5. What are we looking at here, ma'am?
Okay, so this would be where the incident occurred. Okay. And this is where, well, the fan wasn't there, but this is the general vicinity because it's by the fridge and the cabinet and everything.
Now, is there a way to broadcast this up where she can point?
Yes.
Right there.
Wait, is there like a way for her to point on the screen?
There's gonna be. Oh, well, we'll have to get up if you want her to point.
All right, and I will tell you, this doesn't work. If you want to step down, you can step down and point.
Well, maybe I'll do it via laser point. That's okay.
Yes.
Used to have one.
I'm all excited behind, so more than welcome to use it.
Thank you.
It's a little bright thing.
All right, so if you want to point at this screen.
Okay, thank you.
Mr. Rodriguez, this is to turn it on. And I'm going to ask you a few questions here. We heard reference to a knife drawer. Do you see the knife drawer in this photo?
Yes.
Would you please point it out?
Right.
Right there.
Do you have it on?
But it's up there. It's at the top.
Oh, it's too red. It's blending with the drawer. Oh. Yeah, I can point. It's right here.
Just one second. You can step and point.
Thank you, Your Honor. I appreciate it. All right, and that is the knife drawer?
Yes, that's where I stored our family's knives.
Okay. Is that the same drawer where a pink knife was recovered from?
Purple knife?
Purple.
Yes.
My apologies. Ms. Rodriguez, I want to fast forward to when this altercation between you and Anthony occurred. Just talking in the minutes leading up to it, where were you standing?
I was standing in front of the sink.
Okay. Can we see the sink in this photo?
No, you cannot.
If you can tell us where approximately is the sink in relation to, let's say the knife drawer is a point of reference.
Right, so you may stand up and you can stand here and you can point if that will help everyone.
Excellent, Judge.
All right, you can.
Oh, okay.
Yeah, if you want to stand up.
So it'd be about 4 feet from this location.
Point which direction for us, ma'am? Over to the right?
Yes.
Okay, thank you. And unfortunately, I don't know if we have a good photo. What were you doing at the sink?
I was washing dishes.
Was Anthony in the kitchen at this time?
Yes.
And where was Anthony at the time that you were at the sink?
He was in front of our coffee pot on the opposite side of the island.
Do you see a microwave and an oven in this photo?
Yes.
Where's the coffee pot in relation to the microwave and the oven?
May I point to it?
All right, so this is what we're going to do. If you want to remain standing here, you can remain standing here and you can point.
Can y'all hear me?
Yeah.
Okay. There's the coffee pot right there. So he was kind of right here.
Okay.
No, I'll stay.
Just stay up there just for a second. What were you talking? Was there a conversation? What was happening between the two?
Yes, we were talking about who he contracted the STD from, and I wanted their contact information because I wanted to let her and her child's father know about the STD.
Were you angry?
I was upset, yes.
Okay. And just, I think you answered this. We see a fan that's plugged in. Was the fan there at the time that this conversation is happening?
No, I had time to sweep and mop, so no.
Okay. I think you said, well, let me ask you, at any point, did you have a purple Cuisinart knife in your hand?
Yes, I was washing and drying it.
Okay. Was it in your hand while you and Anthony were having this discussion, this argument?
Yes.
Okay. What happened next?
I asked him if I could have their information, and he told me no. And I told him I really wanted to contact them because that's a responsible thing to do. And he told me,
Your Honor, I'm going to object to hearsay.
Overruled.
And okay.
You may continue.
It's coming in.
He told me that he didn't want to make them miserable like us, and I told him I didn't know we were miserable.
Okay. At some point, did this verbal altercation become physical?
Yes.
How did it become physical?
Unfortunately, I talked with my hands, and I was drawing a knife, and He told me he wouldn't give me the information, and I asked him if he thought I was stupid. I asked him if we meant anything to him, me and the children, and I asked him if I was chopped liver, but unfortunately I shook the knife when asking the question, and it made him mad, and he lunged at me.
Well, we're going to take it step by step.
Sorry.
And you can sit back down, ma'am. I don't think we're going to need you to point for a little bit. All right.
Does she talk
So you
with
told
her
him
hands?
you think I'm chopped liver. You said you're talking with your hands. Would you say you're? What do you mean by that? You talk with your hands.
I mean, I was doing this.
At any time, did you make a stabbing, cutting, or any other threatening gesture towards Anthony?
No.
You said it became physical, and Anthony was on the other side of the counter. How did it become physical?
He lunged at me and he pushed the knife into my neck.
Okay. Ms. Rodriguez, are you right-handed or left-handed?
I'm right-handed.
When he pushed, showing the jury, you said he pushed the knife into your neck. Whereabouts on your neck did he push the knife up to?
Up here.
Did it make contact with your neck or some other part of your body?
It made contact with my neck and my hand.
Okay, I want you to stop right there. I'm assuming you're saying your left arm, or I'm sorry, your right arm is the knife. Is that correct?
Correct.
What were you doing with your left hand?
I was pushing the knife down.
Okay, and then were you able to push the knife down?
Yes.
Okay. What happened next?
Anthony picked the knife up and fought with me over the knife.
Did you sustain injuries on your hands as a result of the knife incident?
Yes.
What kind of injuries did you sustain?
I sustained an injury on my fingers and on my arm, my right arm.
Okay. Your Honor, if I may.
Yes.
Okay, she has injuries.
There should
Knife
be in that
injuries.
file right there.
File?
Yeah.
Just one moment, man.
Right arm is where the knife was being held.
Ms. Rodriguez, I'm going to show you what's been previously marked and admitted as defense exhibits 1 and 2. Do you recognize these two photos?
Yes.
Your Honor, may I publish?
Yes.
Here.
Yes. Thank you.
Okay.
Just hold this one on. Thank you, ma'am.
Mhm.
All right. So it may be kind of hard to see, but I want you to do your best for me, okay?
Okay.
Looking up here, let's get it in focus.
You're
not even pushing.
You're fine.
There we go.
Your Honor, if I may have her approach the photo.
Yes.
Ma'am, do you see a bandage on your arm in this photo?
Yes.
Would you kindly point out where this bandage is located? Okay. And what is that?
It's a Band-Aid.
Okay. You can have a seat, ma'am. Why is there a Band-Aid on your arm?
Because when he pushed the knife up to my neck, I feared for my life. And so he struggled with me for the knife. And so when he struggled with me for it, I realized I needed to use the gun that he got me for Mother's Day.
Did you sustain an injury on your arm as a result of the knife?
Yes.
And do you have a scar from that incident?
Yes.
Your Honor, if I may, she showed the jury the scar on her arm?
Yes.
If you need to take off your blazer, please show your arm, please. Ma'am, I'm going to point and touch on you. Is that okay?
Yes.
I'm pointing to a spot right here. Is that correct?
Correct.
Was that injury sustained on the night of November 5th?
Yes.
And was it sustained as a result of a knife?
As a knife point?
Due to a struggle with your husband?
Yes.
Okay. I'm going to give defense exhibit 2. Ma'am, I'm showing what's been previously marked as defense exhibit 2. Do you recognize this photograph?
That's a weird place
Yes.
for a knife injury.
What are we looking at here?
That's blood on my hands.
You're in handcuffs?
Yes.
Okay. How did blood get on your hands?
There were cuts in the creases of my fingers.
Okay.
Those are more believable.
Yeah, I'm going to sit back down for the time being. We need to reapproach help.
Yes.
Thank you.
Most people don't have the willpower to self-inflict that type of
Shelby,
wound.
we may have said it. I don't remember, so I want to talk to you just a little bit more about the timeline. If you know, about what time did this altercation happen?
Around like 2:30.
In the afternoon?
Yes.
Okay. If you know, approximately what time did the police arrive at your house?
Around 5:40.
So is it fair to say between 3 and 3.5 hours elapsed?
It was like 3 hours, 50 minutes.
In that time, did you address any wounds that you sustained?
Yes, I had washed my hands and I was potty training my daughters. And while my daughter was potty training, I put on a Band-Aid and washed my arm.
Okay. I want to fast forward to after the struggle with the knife. Did you pull a firearm, a weapon on Anthony Rodriguez?
Yes.
May I please approach again?
Yes.
Thank you. Ma'am, I'm going to show you what's been previously marked as defense exhibits. Number 9. You recognize this photograph?
Yes.
Your Honor, I'm just going to pass it to the jury. We don't need to show anything. What does that photograph show?
That is the cabinet where the weapon was stored.
Why did you store it in that cabinet? Was there any particular reason?
Because it's up high. It's about 6.5 feet above the refrigerator. The children can't reach it. And because it covers all 3 access areas of the house. So he said that that was the best place to put it.
Okay. Did you grab a firearm that night?
Spoiler alert.
Yes.
Children can reach.
Why did you grab the firearm?
Because I feared for my life.
Why did you fear for your life?
Because he pushed the knife into my neck.
At that point, were you, well, you've already answered. And remind us, ma'am, are you right-handed or left-handed?
I'm right-handed.
I think we saw in the exhibit that you had blood on your left hand. Is that correct?
Correct.
If you remember, were you bleeding at the time that you grabbed the firearm?
Yeah. I don't know. It all happened fast. It was like 10 seconds.
No, I understand. I guess my question is, did you grab the firearm with your dominant hand or your left hand?
No, with my right hand.
Your right hand.
Yeah.
Did you have 2 hands on the weapon or just one, if you remember?
I wrapped it.
Okay.
I didn't want him to get it from me.
Okay. Thank you. Judge, I'm going to sit back down. After you had the firearm in your hand, Shelby, did you say anything to Anthony?
Yes, I told him to back the F off.
It's fine. What else did you say to him?
Okay, I told him to back off, and then he said, "I can't believe you pulled a gun on me." He took a huge leap back and said, "I can't believe you pulled a gun on me." And I told him, "You pushed a knife into my neck." And he looked at me, and he gaslit me, but then he lunged at me again.
He lunged at you again?
Yes.
What happened in the second lunge?
He pushed into me and he tried to grab the gun from me, and we struggled over that's not the kitchen island. We struggled over the kitchen island. And then he twisted the gun kind of towards my temple. I grabbed hold of him. I pulled, like, I mean, he grabbed hold of me. I elbowed, and then launched the gun back up into the cabinet and slammed it and said, "Gosh, that was stupid." And then the gumball machine fell off the fridge and scattered everywhere.
Okay. Did you lift this gumball machine over your head and purposely smash it to the ground?
No.
Once the firearm was back in the cabinet, did you retrieve the firearm again?
I launched the gun into the cabinet.
We talked about the knife, this purple Cuisinart knife. Did you wash it after this struggle or incident with Anthony?
Yes.
What happened after you washed it?
I resheathed it and put it back in the knife drawer.
Did you dry it as well?
Yes.
I think you said that it took around 3.5 hours or so, but until the police arrived at your home. Is that correct?
Yes.
And did you talk to the police that evening?
Yes.
Shelby, did you tell the police that Anthony put a knife to your throat?
No.
Why didn't you tell them that Anthony put a knife to your throat?
Because he was the provider for the family. I was a stay-at-home housewife. I had no income, and then on top of that, I loved him.
Let me ask you, you said you're a stay-at-home provider, is that correct?
I was a stay-at-home housewife. He was a provider. He was our sole income.
My apologies, I messed up the terminology. You were a stay-at-home wife.
Mm-hmm.
He was the sole provider.
Correct.
Did you have any kind of income stream, any kind of means of self-preservation?
No.
Before this incident, when was the last time that you had worked?
Last time I had worked was 2015. He told me that if I helped him get through school and I raised our family and helped him get his master's degree and all that, that I wouldn't have to worry about it as long as I was, faithful and raised the children and was a good wife, and he would support me and always take care of me and love me.
Yeah. Were you angry that night?
Yes.
Were you scared?
Yes.
Just one moment.
Wow.
Just one moment.
One more moment. Lots of moments.
On the night of November 5th, do you wish you would have called the police?
Yes.
Why do you wish that, ma'am?
Because then he would be here and I would be with our children.
Okay. Ma'am, just have a few more questions for you. You admit to this jury that you pulled a firearm on Anthony Rodriguez. Is that correct?
Yes.
Did you pull? Was it provoked by Anthony's actions?
Yes. I would have never done that.
If Anthony hadn't threatened you with a knife to your throat or some other type of physical harm, would you have ever pulled a firearm against him?
Objection to leading, Your Honor. Also asked and answered.
All right, the objection will be to leading will be sustained.
I'll rephrase, Judge. Ma'am, did you believe that pulling the firearm was a necessary level of force to protect yourself at that moment?
Again, objection to leading, Your Honor.
The objection to leading will be sustained.
Did you feel you had to break it down?
Were you in fear for your life?
Yes.
Did you think you had any other options to defend yourself other than pulling a firearm?
No, he had the knife.
Ma'am, thank you. At this time, the defense will pass the witness.
Your Honor, may we approach briefly?
Yes.
It's just.
Okay, while they approach, we're going to skip ahead just a tiny bit. We're waiting for, it was very brief, super brief. We're about to lose the microphone. Here we go. I'm not sure who to believe. Jury's got a tough job on this one.
Write down this for me. Make a chart, preference for. Right, I didn't have time to do it.
Time to Google? What?
Good afternoon, Shelby. My name's Ashley. We've never met. Is that correct?
Correct.
Okay. If I am not speaking loud enough, or if you don't understand the question I'm asking, just ask me to rephrase. I'm happy to do so. Okay.
Okay.
All right. So your name is Shelby Rodriguez,
Yes.
and you're married to Anthony Rodriguez,
Yes.
and you guys live at 3415
We don't need to hear that.
Texas. Is that right?
That's correct.
Okay.
Man, I had to be fast on that one.
And the incident that we're here for today, that occurred on November 5th of 2023?
Yes.
Okay. And just for the record, can you state Anthony's full name?
It's Anthony James Rodriguez.
And your full name?
Is Shelby Jean Rodriguez.
I think they're still
And when
separated.
you would
based on
agree
my
with me that a
Facebook
firearm, I'm sorry, that the gun that you have, the one that you got for Mother's Day, that's a firearm?
Yes.
And you would agree with me that a firearm is capable of causing death
Yes.
and also serious bodily injury,
Yes.
especially if you're pointing it at someone, right?
Yes.
And just kind of a rule of gun safety, you don't point at anybody unless you're going to shoot, right?
Yes.
And you would agree with me that when you pointed the gun at Anthony, I mean, you were threatening him, right, with death or serious bodily injury at that point.
I just wanted him to back off.
And the way that you went to do that was pointing a gun at him, right?
I pointed at Ayden, but it was more of a prop.
Okay. I mean, it was loaded?
I didn't know if the weapon was loaded. He loaded it. I didn't know if it was loaded at the time.
Okay. And I guess going back to my original question, though, like when you point a gun at somebody, that's threatening them with bodily injury, right?
Yes, but I didn't intend, I just wanted him to back off.
Okay. But it was, I mean, you completed the actions, right? You loaded the gun, you pointed it at him, right?
To get him to back off.
And I understand, that's just not my question. My question is, did you raise the gun and point it at Anthony's head?
No, it never went, it was never pointed at his head.
Where was it pointed?
Just at him in his vicinity.
Okay.
But I never had my finger on the trigger, which is why he lunged at me.
Fair enough. Simple question. I'm just asking if you raised the gun towards Anthony.
Mm-hmm.
Okay. Is that you did?
Mm-hmm. Yes.
And when you raised it at him, would you say it was central mass, just kind of in this vicinity?
Yes.
And you would agree with me that if you shot someone anywhere right here, that could cause death or serious bodily injury?
I didn't have my finger on the trigger.
I understand. That's just not my question. If you are pointing a gun at somebody in this general action, or I'm sorry, in this general area, and you shoot it, that would cause death or serious bodily injury?
Yes.
Okay. All right. So just going through your testimony, you guys got together pretty quick and stayed together, right?
Yes, we were in love.
Fair. And how long were y'all married?
We got married in 2012.
So about 11 years at the time of this incident?
Yeah.
And you guys knew each other before then?
Yes, we met in 2006, but we pretty much almost instantly moved in together. He asked me over just about every day, and then eventually, yeah, he gave up part of his closet and said, "Yeah, just stay here," even though I had my own apartment.
And you guys were happy, right? In the
We
beginning?
were. We were. We loved each other. We did a lot of things. He's my best friend.
Still?
No.
And but in the beginning of your relationship, you guys were friends, best friends.
Throughout our entire relationship, up until a certain point, whenever he started hanging out with Blaine Barabbas, we felt like best friends.
Gotcha. What was that name again? I'm sorry.
Blaine Barabbas.
Blaine Barabbas. Is that the friend from work that you were talking about earlier?
Yes.
Okay.
Blaine's like, what?
You guys have those 3 beautiful girls, like you said. Okay. So everything was fine and normal up until around October 31st.
Anthony wanted more attention, even though we had 3 children. So he said that he felt attention starved.
Okay. And I guess my question was, up until then, right? Everything was fine?
Yes.
Okay. I mean, you were here, you've been here throughout this entire trial, you've heard every witness testify.
Mm-hmm.
So I guess what I'm saying is everything fine. You cheated on him though before.
No.
No?
No.
Oh, okay. So he was lying whenever he said that?
I assume he's referring to a threesome that we had back in 2015.
Oh my goodness.
Would you consider that cheating?
No, he was a participant.
Oh, we have a throuple.
So no other instances of you stepping out in the marriage at all?
None.
I had no clue. Sorry, guys.
I want to talk a little bit about your mental health.
Okay.
You also heard him talk about how you had some outbursts prior to this date. Would that be a fair statement?
What he considered outbursts for me, it was me stating my needs.
Okay. You had the number to the suicide hotline?
I called because I tried to leave. I said I wanted to go get a hotel room. And I also said I wanted to go to my sister's. He said he'd call it in as credit card fraud. So the crisis hotline was the only way that I thought I could escape.
And that was the morning of November 5th or a different date?
That was the morning of November 1st or 2nd.
Okay. And so after that, you guys then went on a happy camping trip together?
We went on a camping trip for the girls. I wanted to maintain a sense of normalcy for our children. And so I told him whenever he took the girls trick-or-treating, I said I was going to stay and do the neighborhood trick-or-treating or Halloween. So I passed out candy and water at the top of the hill for all the children because I love children. And I told him that we were not going to ruin their normalcy. We had been looking forward to that camping trip. We purchased a tent, everything. We had purchased a tent 2 weeks, I think 2 weeks before we were looking at tents. And so I wanted to honor my daughters, and regardless of having these marital hiccup, so to speak, I wanted to make sure that our daughters weren't affected.
Sure.
So I said we absolutely have to go on the camping trip. And we kind of, it's the past 2 days, it felt like he had dated me and loved me harder than he ever had. All the things that I'd ever asked for, like opening the door or walking beside me in public, because he usually walked 3 paces in front of me, he did. He held my hand and he made me feel special, and everything that I had been asking him to do over the years just to kind of make me feel almost like an equal, he did.
Okay. And so I guess I'm a little confused. Maybe you can help me understand. Everything was fine up until the 31st, but now you're saying that he didn't make you feel like an equal. He never listened to your needs.
I was very self-sacrificing. He was like a best friend to me, but also he also made me feel like sometimes I was just lucky to be there.
Okay, so why not just say that up front?
I don't know. I'm still confused about what happened to the relationship.
Okay. So going back to you wanting to leave and calling the crisis hotline because you felt like you were so trapped, but then you came back after the camping trip to the house with him and the kids.
Mm-hmm.
Okay. When you went to the ER clinic, you said you were there from 5 a.m. to 8 a.m.
Mm-hmm.
Can you walk us through exactly every test that you had? I mean, I know you were in the waiting area for most of that time, I'm sure, but when you got back to the doctor's office, what exactly did they do?
So I was pretty distressed.
Your Honor, we can approach, but the relevance is that they brought it up and I'm just trying to go through.
Yes, let's approach on the relevance.
Let's approach on the relevance. We're going to speed this up a little bit because we're going to have closing statements here in just a bit.
So at the doctor's office, they gave you a shot.
Yes.
Okay. They gave you a shot in your butt.
Mm-hmm.
Okay. Did they give you a shot anywhere else?
Right in the keister.
No.
Okay.
I've got a story about that.
They gave you pills then?
Yes.
And I mean, eventually you got your results back and everything was fine. There's no STDs, right?
Yes.
Okay. So it was all kind of over nothing.
I look at it. He went on Sunday as well. He left that off.
I'm so sorry. I didn't understand you. What was that?
Before October 31st on Sunday, when he was supposed to be dropping off Goodwill donations, he went to the same clinic that I went to initially, and he was seen because he was trying to not tell me. So I don't know how much medication he had in his system, but he did go on the Sunday before, and then whenever he came in with, he went to, so I went to, it's the clinic off of Bulverde, Bulverde and 1604.
Not a sponsor.
And I went there, and he went to the Methodist Hospital after, and then he came back and he found out that he didn't get a full STD panel like I did. So he said, no, I want to go to the one that you went to. Well, I told him, I'll go with you since your parents and you wanted to let the kids stay over there. We'll go together. And he told me, no. And I said, oh, you let's go together. We need to go together. I'll be your support buddy. Don't worry. We get in there and the receptionist says, oh, Mr. Rodriguez, you're in here again, because he was in there on Sunday. She said, weren't you just in here on Sunday? And I said, oh.
Objection, hearsay.
So he had already been seen at that same place on Sunday.
And you're saying the Sunday before October 31st?
Correct.
Okay. And then on October 31st, you went to go.
Correct. And then
y'all went to go again.
He went to 3 different places, yes.
Okay. Gotcha.
Wow. They just let her talk, didn't object to hearsay. You asked the question, ma'am.
Have you ever called the crisis hotline before?
No.
How did you call?
I looked up the number on Google.
I apologize. What phone did you use to call?
My cell phone.
Your cell phone? Okay. Had you ever been treated anywhere before?
No.
Have you ever, I guess, does mental illness run in your family at all?
Objection, relevance.
Sustained.
No.
Okay, fair enough. Have you ever,
Sustained.
let me withdraw that part. I want to talk about your version of what happened.
Mm-hmm.
So you said on the morning of, on November 5th when y'all got back, you were washing dishes?
Correct.
Okay.
We take turns, so yeah. He was unpacking the car, so I was doing laundry and dishes and taking care of the children.
Okay. And part of the dishes was the knife?
Yeah.
Okay. And I'm assuming when you were washing the knife, it didn't have the sheath on it?
No, but I washed both together. It's a cleanliness thing.
Right, no, that's fair. But provided you wash the knife without the sheath on it, and then you would wash the sheath separately, is that correct?
Correct.
Okay. And then you said you had dried it and put it away. Did I hear that correctly?
No, I didn't. I didn't put it away. I had it in my hand, and I had the towel in my other hand whenever I was,
What hand did you have the knife in?
The knife was in my right hand.
Because that's your dominant hand, right?
Yes.
Okay, so you had the knife in your right hand,
Mhm.
and then the towel in your left hand.
Yes.
And you guys are arguing, and you're talking with your hands. I do the same thing. Right.
Correct.
And then you said at some point he lunged at you.
Correct.
Okay. When he lunged at you and you had the knife in your right hand and the towel in your left hand, how did the knife go?
I dropped the towel, and it was up here.
But you would agree with me when you were testifying on direct, there wasn't any mention of a towel, right?
Correct.
Okay, so the knife, Your Honor, may I have the witness demonstrate in the well areas?
Oh.
You can step down, Ms. Rodriguez.
Okay.
This is a dirty tactic. Let's get the defendant with the weapon in front of the jury. It's.
You said you have the knife in the right hand? Yes. Okay. And then he lunged at you? Yes.
I don't think she has the weapon though.
Here. Okay. What side was the blade on? Was it facing towards me or facing towards your neck? It was facing
Crank
towards
this
my
up.
neck. Okay. And so then what was your left hand doing?
I grabbed it and pushed down
Okay. And where was your left hand on the knife?
on the top of the blade.
On the top of the blade, in between the blade and the neck?
I put it down.
Okay.
I'm sorry, I don't understand.
Okay. So at some point the blade did touch your neck.
It touched my neck.
Okay. And it was with force when he lunged at you?
Yeah, but it's a dull knife. It's kind of dull, so it's huge.
Okay. It's a dull knife?
It's a little dull, yeah.
Okay. But it cut your fingers?
Yeah.
Okay. You can sit down.
It's the best I can do on boosting the audio. 20 decibels.
Yeah, that's fine. What are they, 38? Your Honor, may I approach?
Yes.
This one. Good. Okay. Shelby, I'm showing you what's been marked as State's Exhibits 38 through 34. Adam.
Oh, you're being careful. We didn't hear for you, so you're fine.
I apologize, I misspoke, Your Honor, 38 through 44. Take these. Go ahead. If you could look through these.
Okay.
Let me know if you recognize them.
Yes.
Right. Are those, what are they?
They're pictures of me the night of the incident.
Okay. And they look like you remember yourself looking that night?
Yes.
Okay, they haven't been changed or altered.
Mm.
Okay. Your Honor, state will offer into evidence State's Exhibits 30 through actually 45. 38 through 45.
There we go. Okay.
And so fucking.
Hmm?
Yeah.
No objections, Judge.
All right, States Exhibit 38 through 45 is admitted without objection.
Oh, these are yours.
All right.
What is yours? Oh, thank you. And these two. Yeah.
All right, States, you may proceed.
Yes, Your Honor. Sorry, I'm just going through the exhibits. All right. Ms. Rodriguez, showing you States Exhibit 38. Do you see this?
Yes.
You'd agree with me there's no injuries on your neck, right?
Correct.
And I'm showing you States Exhibit. Oh, I apologize. 44. There's still no injuries on your neck?
Correct.
And States Exhibit 45, the other side of your neck. There's no injuries?
No injuries.
Okay. You talked earlier about a scar on your arm.
Yes.
Can we see that, Your Honor?
Yes.
Can you step down so that we can see that? Yes.
Okay, I've got to crank this up again. It's a little pointy, little tiny mark.
Right here. Can you show the jury?
Can you show the jury?
And is that circular? Yeah, right there. Now, thank you so much.
That circular area?
You just talked about a couple other scars and bruises on your arm that you didn't mention earlier. Is that right? Oh, I apologize. Please get settled.
Yes.
Okay.
Fix your collar.
You'd agree with me in this photo, there's some discoloration right there. Is that correct?
I guess, yeah.
Yeah, little circular discoloration.
That's the other arm. The arm that's on has a Band-Aid. There was a Band-Aid.
Right. The Band-Aid's right here. It might be a little light because it's in black and white. Sorry.
Yeah, that discoloration you're talking about, that's my elbow.
Okay.
That's my elbow.
And on this, you'd agree with me there's some discoloration there.
Again, that's my elbow. That's I had 3 children, hormone stuff, discoloration.
Okay. Oh, no. You'd agree with me that those circular discoloration on your arms look like the one that you just pointed out to the jury, right?
No.
No?
No.
Okay. Earlier you said that the knife was dull?
Yeah.
And it didn't cut your neck?
No.
But it cut your arm?
It did cut my arm, yes.
Okay. Want to talk to you about, let me see if I can get a good picture here. This cabinet in States Exhibit 25.
Mm-hmm.
You said that's above the fridge?
Yes.
About 6.5 feet above?
Mm-hmm.
Okay. And you guys were in this area in State's Exhibit 15, right here in between. Let me back up. Is this the fridge handle right here that I'm pointing to, that silver?
No, that's the bottom of the fridge. That's the bottom of the fridge. This fridge, the model and make, the handle actually goes horizontal, so that's just the bottom of the fridge.
Oh, I understand. I'm sorry, but this whole silver area, that's the fridge. Is that correct?
Yes.
Thank you. I apologize. You guys were standing in between this island and this fridge during the struggle?
No.
Okay. Where were you standing? I apologize.
It would be further over that way by the countertop because he pushed me into the countertop.
Your Honor, may we have the witness stand and point?
Yes.
Yeah, she says.
It would have been 15, like right here.
Right there. Now, okay, I see.
It's further this way.
I see it now. It's
I
over
don't think
there.
we have a good picture of that.
Didn't take a good picture of that area. No.
I don't know.
Yeah. Okay, so you said it was further this way, like closer to these drawers?
No, it's the opposite side. Like it was sink side in front of the dishwasher.
Cops didn't take a picture of that area.
Let me back up. The gun cabinet, is that right above here?
Yeah, but like 2 feet over, like maybe 2 feet over.
Okay, and is there more space between the island and the cutoff picture that
Yes.
we're missing?
Yes.
Okay.
There's a better picture, but yes.
Okay.
They're trying to find the picture. Can you try to find it?
All right, showing you State's Exhibit 22.
Okay, yeah.
Okay.
Yeah.
Where were y'all?
Okay.
Y'all. We got a y'all.
By the dishwasher. Okay. And now looking at State's Exhibit, I'm just going to do this. 15.
Like right here.
Okay. And so in State's Exhibit 22 is the fridge on the right side of the dishwasher. Like as we're looking at State's Exhibit 22, is the fridge on the right side of the dishwasher?
If we're facing the dishwasher, yes, it's on the right side.
Okay. 6.5 feet above that is the gun cabinet.
Yes.
Okay. And you guys were fighting over here?
No, we were closer to the dishwasher. Like we were right up on that right there. Cause he pushed me into that.
Into this cabinet?
Yeah, he pushed me into the counter with the dishwasher.
Like by the dishwasher?
Yeah.
On the dishwasher?
Well, oh yeah, the counter with the dish right there. Yes, this part right here.
This part right here.
Yeah.
She's trying to say, how do you make
So
that
he pushes
shot
you
with
there.
the
How
gun?
far would you say, it looks like there's some space between this counter and the fridge. How many feet are in between that? Just to your best guess.
Like maybe 1.5 feet, maybe 2 feet. About 2 feet. I just leaned in.
Is there a walkway? Like people can walk there in between this countertop and the fridge?
Yeah, but we were struggling.
No, fair enough. But like just in your everyday life, there's a walkway there for people to
Yes,
walk
there's a
through.
walkway right there.
Okay.
Yeah, it's the entrance to the kitchen.
Okay, so it's a kitchen entrance, enough room for a kitchen entrance.
Yes.
Okay. And so he pushed you into that cabinet, and then you said you were able to jump up and grab the gun?
When I pulled the knife down, he got a hold of the knife. I went to grab the gun. I jumped up. I got it out of the cabinet. When I was pulling it down, I don't know what he was doing all over here. Yeah, I pulled the gun down on the knife. Boom, boom, slammed the door shut, and then he took a big leap back. He stepped back real far, and then he said, I can't believe, he said, oh, Shelbs, you pulled a gun on me. I can't believe you pulled a gun on me. Like he was scared, and I said, back off.
And how tall are you, Shelby?
I'm 5'7.5", 5'8".
And the gun cabinet is over your fridge, right?
Yes, but I'm tall.
Sure, sure. Does your fridge stick out from the cabinet a little bit?
A little bit, yes.
Yeah. And then you were able to toss the gun back in there and slam it?
Mm-hmm.
I can feel the defense attorney shaking his foot from here when he does that. Yes. He's a shaker. Not that kind, but front door.
Earlier on direct examination, you said you guys were really close. Obviously, like he was very close to your body while you were struggling with the knife. Correct?
Yes, he was in MMA, so he's experienced, and he kind of keeps a little box. So I mean, he was close, and he was getting close, and then he would give a little distance.
She fought off a
he's
mixed
experienced
martial
in
artist.
combat.
Okay. And so while he was very close to your
With a
body,
knife?
you were still able to jump up and grab the gun from 6.5 feet over your fridge with your fridge sticking out a little bit.
Okay, what's his fight name? Can somebody tell me what this man's fight name is? I think it's Gumball Rodriguez. I think that's what he fights under. Gumball Rodriguez.
Just 1 second. You'd agree with me that a knife can cause death or serious bodily injury?
Yes.
You'd agree with me that you pointed the knife at Anthony while y'all were arguing?
No.
Okay. Did you, I mean, while you had it in your hand and you were mad at him, you never pointed it at him?
No.
Okay. You never threatened him with the knife?
No.
When police got there, you entered the door, right?
I did.
And you invited them into your house?
I did.
Okay. And then eventually you guys went out and you were talking on your porch?
Yes.
Okay. You were sitting on your porch you were standing on your porch initially, is that correct?
Yes.
And then you moved to your porch chair where you were sitting?
Yeah.
The green one?
Yes. Oh, well, it's a rocking chair.
Rocking chair, yeah. And you guys were just kind of chatting, is that correct?
Yes.
At that point, you knew that the police had been called, obviously.
Yeah, they were there. Yes.
Okay. But you didn't call the police, right?
No.
Okay. Even though you felt like you were in fear for your life.
I was going to call them. It should be in the body cam footage. I told them I was about to call y'all. That's why I let them in.
But you were going to call them for something different, right?
Yes.
Not for what happened between you and Anthony.
No, I was going to call them and see if they could give him an escort while he collected his belongings because things had escalated as they had.
And you were mad, right, about the cheating? You were angry?
I was mad about the infidelity, but I was also just in general confused. There was a lot of emotions going through me that day. That's probably the most distressed I've ever been. Yeah.
You were especially mad because he took his ring off, right?
I was mad about the calculation.
Because it was premeditated, right? If he took his ring off?
A little bit, yeah.
Premeditated mistake.
Your Honor, at this time, may we approach?
Yes.
Fast forward. She walks around, then she sits back down. You're not done. Just wanted to see where she was going. Now she's down. Now we've got an officer on the stand. The officer's just going to say what he saw and what they told him. There we go. She gets up, she gets down, jury comes back in. I think this is where the Josh says the audio goes bad. Premeditated cheating, but different from the adding an additional partner consensually, apparently. We just glossed over that.
Shelby, you were fuming. Oh, I apologize. When police got there, you were still fuming, mad. Isn't that correct?
Actually, I wasn't. I was mad when they arrived because I was surprised that they were even called.
Right. When police got there, you were still, or you were angry.
I became angry again.
Angry. Okay. Your Honor, at this time, state would offer into evidence State's Exhibit 37A.
All right, defense, your previous, could I have parties approach?
Of course.
Sidebar after sidebar after sidebar. Trying to get to the closing statement, so it should be happening this morning, but have not started yet. If somebody could explain that to me.
Counsel wanted to see me at sidebar.
I don't know why. She said we were going to start at 9 this morning. What time is it in Houston? Is it a time zone thing? Did I do my math wrong? Is it starting at noon? It's 10:42 in Houston. The jury's just been sitting on their hands for ages.
Yes, Your Honor, I'm just trying to figure out the best way to publish it. Your Honor, any objection to me displaying my laptop right there?
Now, defense, you may move about the room.
Thank you, Your Honor. I may just post up in the corner. If
Yes.
That's okay.
Post up.
Sure.
Do a little 6'5" there in the corner. It's 10:43 in Houston.
Oh, it's on video. Oh my gosh.
I need all the clocks petrified. I need everything. The entire U.S., including Hawaii, and practically to the Bering Strait. They might be having technical issues, especially considering they had technical issues to end the day yesterday. I think maybe the judge got a whole bunch more flowers and they're blocking the Wi-Fi signal. I think that's what it is. Charges in this trial, the wife, Shelby Rodriguez, is charged with 2 counts of aggravated assault with a weapon, one for the knife and one for the gun. Obviously, the husband not charged with anything. He's the victim in this case, and it's all over an affair.
Mm-hmm.
Husband calls it, "I made a mistake." His mistake involved taking off his ring on a business trip and hooking up with somebody. And can't believe why the wife was mad about it. I mean, he told her a week and a half later when he thought he had an STD about it. Well, he didn't really tell her about it. He told her, I think I might have an STD, which is not the way to start that conversation. If you need to have that, that's not a good opening line. It's like, hey, I think we should get checked. Husband was an MMA fighter. Don't believe either one was frightened of the other person.
Your Honor, for the record, I'm pausing it at 1 minute 56 seconds to change to my size. That was Frank's. Oh. No. 56. Windows.
Mandy Mulu, I believe over half the states in the United States have at one point or another passed a resolution that basically says if everyone else goes for it, we're going to get rid of daylight savings as well. Might happen. Might happen.
Okay.
This might be my favorite trial emoji summary yet. Oh, no. Oh, my goodness. I can't wait. Bree does trial summaries with emojis, and they're spot on.
There will be audio.
He's a genius. But I caught him in a lie because he had a itchy groin and it was burning. And I was like, oh, okay. And I was like, he's maybe Pickles. And dumbass fucking one of those symptoms. And I'm like, oh, you're cheating. And his parents took the kids for 3 days. And he got through that. But then today, somehow it seemed to. Oh, because I wanted to contact Sarah's husband and boyfriend, let him go.
That's the other half.
Yeah.
Okay.
In Florida, Sarah, 38. Well, Auntie looks like me, but she has a better midsection, so she can explain it. Yeah, he's good. He's live in Florida.
I'll work then.
Yeah, we're. Oh, yeah.
Okay.
Yeah. Okay. So I told him I wanted the fucking truth because he was lying. So yes, I was like, I will get my gun and I will point next to it. I speak at him and I yelled at him and told him to get the fuck out of my house. Because
you go.
There's a confession.
It's not moving.
She comes out with the FAFO.
You pointing at nobody and all that. So who would have called? Obviously, it wasn't you. Oh, Tom.
I'm sure it was him or the neighbors because our AC is broken and that's probably what happened. The windows are open and my kids said, hit the food, our the back porch. I don't know what about. So I'm pretty sure it was him. So it would be already for him to call. So,
I think right there she's admitted enough.
Move forward. What else?
That we could go with the guilty.
It's Rodriguez, it is.
At least on the gun.
That's the serving what?
Is it constant message to you?
Yes. Car.
Denver?
Mm-hmm.
Denver?
September 26, 1984.
And what's your phone?
When you call like this.
What's up? What's it?
Anthony.
Water?
Mm-hmm. His other parents, but he want to go get our daughter a a gumball machine, and she had it on top of the fridge, and when I opened the fridge, it fell down and broke it. It is January 2nd.
This is terrible audio.
I'm sorry, I caught 281, I caught 381.
Their numbers.
Just year of court this year. Just to make sure I understand. It was an argument over the fact that broke, of course, we caught you cheating, and you wanted him gone. And
I kept telling him to get out. I let him gather all his things. I told him I was going to call the police. I need to know how to proceed with this. I have to call the divorce lawyer tomorrow, and I want you to find out legally what is he allowed to come into the home to get and when and why, because I don't feel comfortable with him being in the home right now. I'm not comfortable with him being in the home at all.
that is definitely a good question for an attorney, civil attorney.
She said divorce lawyer.
So walk me through one more time about the whole gun situation. Well, somebody mentioned it to us. I need to know why. Right?
Because he was already lying to me. He had 3 days to walk me through everything.
I'm sorry, could you pause for a moment? The parties approach.
Parties approach. I keep checking to see if Judge Boyd is going to go live here with the trial today, and I'm not seeing it. Where's she at? Sounds like she admitted there on the tape with the body cam to the police officer that that she said, yeah, I was mad. Grabbed the gun, said, you've been lying to me. FAFO. Tell me the truth. So I pointed the gun at him. What? That's basically the whole case just wrapped up into one big confession. You might say you lied to the cops, but you lied in a confession. That's going to double whammy you. This is where the audio goes out. Judge Boyd is distracted, doesn't know the audio's off. Oh, now she saw it. Turns it on. Click, click, click. We see the acting. We see the faces. We don't hear the audio. The two faces.
No, we have no further questions. We'll pass the witness.
All right. Any further questions from the state?
No further questions, Your Honor. We are no further questions.
All right. You may step down.
Thank you, Your Honor.
All right. Defense, any other witnesses?
This time the defense would rest.
All right. State, do you close?
And are we rest and close?
We will close.
All right, ladies and gentlemen, I'm going to have you all back here tomorrow at 9:45. At that time, parties will be able to present closing arguments if they choose to do so. Remember my previous instructions. Do not think about this case outside of this courtroom. Everyone, please rise for the jurors.
She said 9:45. And I'm not seeing it.
All right, and Cindy, before we go off the record, just one moment.
Ashley waking myself up.
I know. Rick moved it closer.
No, just a moment. Cindy, just one moment. We're going to go on the record in just a second. So, guys, the reason why I ended up changing it because I was able to hear it better. And his asking her like 3 times about this gun that changed the court's opinion. So we'll go on the record so the record can be clear with my ruling. All right, we're back on the record. State's Exhibit 37A, the court is finding that the statement was voluntarily given, that the witness was not in custody. However, the court is going to rule that in 37A, at time 5 minutes and 58 seconds, anything after that time period, the court is going to find that the defendant should have been Mirandized and legally should have been Mirandized at that point, because at that point it was an interrogation and the accused statements were not being voluntarily and knowingly given. All right, thanks.
Thank you, Your Honor. And just so we're clear for the record, I assume the state, and we have no objections to it, we'll just replace 37A with a new video that cuts off at the 5 minute and 58 second mark.
Yes.
And we can do it tomorrow. I'm
Yes.
sure everyone's ready to go.
Nobody's scared to do it.
This
And what time you got there, Judge? 9:45?
Yeah, that's for them. That's not for us.
I would say to be here by 9.
Yeah, but you guys have the charge.
Yeah.
So look over
I
that.
fell asleep last night reading. I'm
No,
gonna
no,
read
no.
some-
So look over that. And if you all can be here at 9:15.
You got mine?
Okay. Yes.
I have many courts sending me nasty grams because I was
Oh, send it to me and I will send them
I was gonna say-
nasty grants.
text Laura.
Yeah.
Well, yeah, just you know how it gets.
All right. So anyway, my understanding that there has been issues with regards to the first floor.
And she's gone. All right. I'm not sure if we're going to find out the solution on this one. I'm not sure if we're going to get the closing because the court said it was going to start at 9:45 and it's now past then. And we're still waiting for Judge Boyd to go live. Let's see. For some reason, they're late. And I have no idea why. It is Friday, so court hopping options are a little bit limited unless we do landlord-tenant, which I'm not a big fan of. Well, actually, Judge Middleton has some misdemeanor stuff. Let's jump to that while we wait for Judge Boyd to get her act together. So, we're on 8, sorry.
27 days, credit 27 days, waive those additional fines. You got some other stuff, plates and speeding and some other things that are civil infractions, but I've wiped out your other misdemeanor.
That's nice of you, Judge.
Have they taken anybody back yet, Joe?
No.
So we're taking all 10 of them, they're gonna get the van or something?
No, we're gonna have to make several trips.
All right. Mr. Johnson, stop driving, all right? You've got better things to do than spend a month at jail in a beautiful month of September and October. I wiped out what I could. You're good to go.
Here we go. Backing up a little bit.
Let's talk to Mr. Salmon.
Grim Faded, congratulations.
So they both
passed
in
the bar.
custody?
No, I got.
Let's do Chad.
Okay.
They're all
So
missing
glad that's
lunch.
And Your Honor, do you have the sheets for Dean custody fellows up there with you?
No.
Grim Faded, congratulations. Can't wait to see you in one of the courts we follow.
Mr. Chad Salmon will be a plea to retail fraud in the second degree.
All right. I also have to arraign him on a new charge.
Keep looking for Stephanie Boyd. Give me a second if I can find. If they're just late starting, we'll find it. Judge, where are you at? What if she took a deal? Thurston will have some non-landlord stuff at 9 a.m. Pacific. Thank you, Rocky.
Good morning, Mr. Solomon.
What time is that?
It's been a long morning back there in the back.
Yes, it has.
You're Chad Ryan Solomon.
Yes, sir.
Mr. Solomon, you got two files.
I just missed a call from another neighbor, not the one that mows my lawn. Give me a second. I'm going to make a call. Be right back.
The first one is a pretrial with Mr. Truckee. In that case, the allegation is that you committed 2 retail frauds and filed 251766. You and Cassandra Stratton are the Myers store. They're going to dismiss the retail fraud conspiracy, and you're going to plead to a retail fraud second degree. It's alleged that you and Ms. Stratton stole some property from the store on that day.
It's not like the cheat sheet. I have Mitchell Solomon. I think it was 2.
Yes.
So I apologize for that. I just that one.
Are you going to plead to that charge?
Yes, sir.
Anybody threaten you to get you to plead to that charge?
No, sir.
Or promise you anything?
No, sir.
I gave her time served and a bus pass. Let's see how long you've been in jail. $57 days credit. Anybody? All right, let me go through your rights. You understand that if you plead to this charge, you'll be giving up your right to have a trial in front of a judge or jury. There will be no trial. You understand that?
Yes, sir.
If you had a trial, you'd have the right to be represented by an attorney. Mr. Truckee is here with you. You could also hire an attorney of your own choosing if you wished. If you had a trial, you'd have a right to have any of the witnesses for or against you subpoenaed to come to court so they could be questioned under oath. You would have the right to take the witness stand and testify on your own behalf. But you don't have to because you have a right not to testify. And if you did not wish to testify, the judge or jury cannot hold your silence against you. And you have the right to be presumed innocent unless the state was able to prove your guilt beyond a reasonable doubt. Understand?
Yes, sir.
All right. We looked at this. We learned a little bit from your co-defendant. Were you and Cassandra in the store on that day, July 14th?
Yes.
And did you put some stuff in a backpack and then walk out with it?
Yes, I did. I never left the store completely with it.
They saw you on bicycles and then you left. I thought the stuff went out the door.
No, I dropped it at the doors.
All right.
Just had intent, but you got caught.
I'm going to order 57 days jail credit, 57.
They're supposed to be live. I don't know what the delay is. Could be a juror issue.
0 fine. $125 or 2 additional days concurrent with your other cases, including 251988FY.
Maybe the couple patched things up, got back together. Friday turned into a disaster. What happened? We're waiting for the other case to start in Houston.
We still got another party with kids out there?
Yes. That is going to be a bond motion.
All right. Mr. Salmon, you also have a new charge of possession of methamphetamine. It's alleged in file 251998 that on August 6th of 2025, you did possess methamphetamine in the city of Three Rivers. That's charged as a 4th habitual offender matter. What? That is punishable by theoretically up to life in prison.
Whoa, fourth.
That must have been
offense.
just before you got lodged on this.
When they arrested me for it.
All right, I don't know what took so long for it to get authorized, but it was given to me yesterday. So I'm going to show that you're pleading not guilty in that charge. I'm going to appoint attorney for you. They didn't think I had enough to do, so they gave me a couple extra things. You're not guilty.
Judge has a busy day today.
Mr. Truckee is here with you today. He probably will not end up representing you on this.
Happy to act as public defender.
Yes, thank you. Set attorney pretrial or set PEC for 10/4. Well, that's not 10/14 at 8:30. And a preliminary examination if needed for 10/21/25 at 1. My counsel. Set bond. This is a life offense. They had scheduled at 10,000 cash or surety. Shall personally appear for any hearing, including the pre-exam conference, abide by any judgment entered in the court, by the court, do not leave the state of Michigan, do not commit any crime if released, provide email and telephone number upon release, do not use drugs or alcohol, do not possess or purchase a firearm. I think Autumn had already said it, but I'll sign it.
Judge is signing everything today.
All right, Mr. Solomon, this took care of the retail fraud. We got to deal with this new methamphetamine case. We'll address that at your pre-exam conference on September 14th at 8:30.
Thank you.
Who do you have left back there? There's one female.
There's one female.
And who is that?
Cheyenne Smith.
All right, let's bring her in. She's next up. 1, 2, 3, 4, 5, 6, 7 more folks.
Out of these folks, I have 3 that are pleased.
Let's do Victor Castro Ortiz. It's here.
No.
That's John Bush. Oh, that was set a last pretrial. That's not even it. So let's see what we got here.
I've got many of these sheets. Mitchell Salmon, his last pretrial.
All right, Mr. Salmon, would you come forward? This is file number 251644 SM. You're Mitchell David Salmon.
Yes, sir.
You're charged with assault and battery. It's alleged that you assaulted Clarence McWaters on or about August 21st. You pled not guilty to that charge. We're going to set this for a last pretrial conference. That'll be on a Thursday at 2. We're going to be very busy on some upcoming Thursdays. I thought you had owed me some money, but I couldn't find anything that showed that you did.
So you just slipped me a $20 bill. We'll all be even.
But I couldn't see that you did.
I paid in May, 260 owed.
All right, very good. All right, Mr. Salmon, thank you for your patience. You're good to go.
Thank you. It'll be a Thursday. Okay.
Be well, Mr. Solomon.
Make sure to get a hold of the microphone. This is Miss Cheyenne Smith. I think you wanted mystery one.
Yes. Good morning. Are you Cheyenne Riley Smith?
Yes, sir.
Miss Smith, you're charged with retail fraud in the 3rd degree.
Walmart.
Or 2nd degree. That's punishable by up to a year in jail and a fine of up to $1,000. Prosecutors agreed to reduce that to a charge of retail fraud in the 3rd degree, which is a misdemeanor, punishable by up to 93 days in jail and a fine of up to $500.
It's got to be Walmart.
Let's take a look at this. It is alleged that it occurred What happened to 251877? That is a charge of fail to stop at the scene of a property damage accident.
Yes, that would be, there's a plea as charged in that file.
All right. Do you have that one?
No, I don't have all the folks that were in custody. I don't know if Autumn and I didn't exchange them or what.
I got
Those
nothing.
are Melinda Fowler.
I got nothing, Judge. Don't have any of the files.
I'm looking for the sheet on Cheyenne Smith, 251877. I'm getting loopy here. Lack of a chocolate chip cookie.
Do you have no cookies, Judge? That's terrible. We need to remedy that. Let's Uber the judge.
Well, there's always something. Let's see if we can find this one. In this case, Miss Smith, the allegation is that you were at the Walmart store in Three Rivers, which seems to be the popular place for stealing stuff.
In front of the Walmart.
And you stole property that was worth less than $200, which would be retail fraud in the third degree. The allegation is that you stole a bath brush, razor, toothbrush, some other personal items, and some steaks.
Steaks. Those are the big
worth
rates.
$186. That was in March.
It's got to be what, 4 steaks?
Are you going to plead to that charge? Is that yes?
Say how
Yeah.
You can just say.
Yep, yes, sir.
Okay.
Oh,
I can see you be out. You've been in jail for 20 days. Anybody threaten you to get you to plead to that charge?
no, sir.
Or promise you anything?
No, sir.
Do you understand that if you do plead to this charge, you'll be giving up your right to have a trial in front of a judge or jury? Do you understand?
Yes, sir.
I found the other file. I found the other file. All right. I got to do this again. Do you understand that if you plead to this charge, you'll be giving up your right to have a trial in front of a judge or jury? There will be no trial. Do you understand that?
Yes, sir.
If you had a trial, you'd have the right to be represented by an attorney. Mr. Truckee has been appointed to represent you. You could also hire an attorney of your own choosing if you wish. If you have a trial, you'd have a right to have any of the witnesses for or against you subpoenaed to come to court so they could be questioned under oath. And you would have the right to be presumed innocent unless they were able to prove your guilt beyond a reasonable doubt. You understand?
Yes.
Were you in the store on that day, which was April 21st? March 21st, excuse me. Yeah, March 22nd.
Yes, sir.
And did you take these items? Put them in your purse, stopped at the exit door, refused to show a receipt.
Yes, sir.
Did you take the stuff or did they recover it?
Did they recover? I don't think they did they?
All right.
So they didn't get you then?
Yeah, there's a list of unrecovered property.
Okay.
It was recovered?
There's a list of not recovered property. So there was 186.62 not recovered.
All right. I'm going to order 20 days jail credit, 20 days. You're going to get out of jail today. Do you have someplace to go?
I need to turn this, well, I need to add things that priorities I need to take care of, and I need to go get this medical scan done. I missed my medical scan while I was in county. I'm 20 weeks pregnant I'm about 5 months, but I missed my 20-week scan. So I need to take care of medical and go back to India.
All right. Well, I didn't realize you were pregnant. I'm sure the sheriff. One thing I tell judges at new judge school, don't ask somebody if they're pregnant. Because you might be wrong and you might hurt somebody's feelings and be embarrassed. So I'm going to order the minimum 125 and 187. 187 is restitution to Walmart, so you owe $312
Math is
by the end of the year.
Halloween song costume contest.
Then you're barred from all Walmarts for 1 year.
In front of the Walmart.
1 year of no Walmart. I'm not sure how people can survive.
Why did you take this stuff?
The things that were unrecovered property, I needed it, and that's not a good enough excuse. You should never defraud places of corporate businesses, other people, etc. But lack of having had a job, lack of resources.
I would note that they're almost all personal care.
Yeah.
That's what it looked like.
And food, but still no excuse made. It was the wrong thing to do.
Yeah, but you weren't stealing loaves of bread. You were stealing the steaks. She wasn't stealing ramen noodles, right?
All right, there's that one. Now let's talk about the traffic case.
The baby's a carnivore. Eating for two, yep. For those that missed it this morning, we're planning out the channel activities for Halloween, and we're going to live stream the trick or treating at the RA household. Yeah, we're making the front yard a crime scene, fake crime scene.
All right, this case alleges leaving the scene of a property damage accident. Let's take a look at this one.
I need to find the black plastic bags that you, like the shape of a body. Somebody texted me a picture how you make the body out of water bottles.
In this case, it's alleged that you were driving a Chevy Equinox. You were in an accident on South Centerville Road and left, hit somebody in a Volkswagen Passat. Then you went into Indiana and crashed into a barn. It sounds like you were maybe impaired by alcohol and/or prescriptions. Did you hit a car in Sturgis and then take off?
I ran the red light, then I waited, and they made like a few different movements as to which direction they were going, and then I tried to go around them, and then we collided. But I didn't run the red light and hit somebody, but I did end up, there was a collision after I ran the red light.
All right, you ran the red light, then there was a collision, then you left.
Yeah.
Did you get arrested in LaGrange?
I got arrested hours later in LaGrange County, yeah.
And how long were you in jail in LaGrange?
About a month, and then I transported to Allen County. I didn't know I had a warrant out in that county.
Oh, you're burning the candles at both ends and the middle.
Unfortunately.
Okay, here we go.
Where are you from originally?
Hold on.
County.
We're jumping. We're backing up to the beginning. What did we get? 15, 20 seconds ago. Here we go. She just barely went live. Give me a second. I'll get the better audio on this one.
I don't plan on using them. Well, maybe some of the photographs.
Steve?
Well.
There we go. Better audio.
Maybe some of the photographs.
Okay, we've got the finish. We saved it.
We have
Can you please turn your mic on so we can hear you? Or off. Did the bailiff just turn the mic off? Let's skip ahead to the current. We're only like 30 seconds behind, but let's see. Still no audio. So they're prepping for closing arguments now. I'm not sure why they're so delayed. It's 12:30 my time. Lunchtime. I was about to take a break. While they do this, Halloween, I'm going to tell you just really quickly. Yes, everyone's saying Judge Boyd is live. We're watching Judge Boyd right now, which means you're probably delayed on our live stream. So let's see. Let's pin this one. Halloween plans go like this. I'm going to have possibly a fog machine. I'm looking at getting a fog machine, if I can get one cheap enough. Our candy is either going to be in individually packed evidence bags, if I can get little clear, like 3x5 size, little plastic evidence bags, or if those are way too expensive, which I think they would be because we get about 500 to 600, maybe more, could be 700 trick-or-treaters. We might have to just have one big, like a brown paper bag, evidence bag that we hand candy out of. We're going to have everyone who's handing out candy wearing the Tyvek suits, the white crime CSI suits. I might park my white SUV on the lawn with CSI in black electrical tape written on the side or something like that. I've already got over 40 pounds of candy. That should be enough, I'm hoping. Aren't you worried about some parents aren't okay with them streaming their kids? Not in the tiniest bit, because they don't understand the law if they have a problem with it. And it's public. They're in public. So, 50 for $12.99. See this, that would be $130 just for bags, Gina, if I got 500 of them. I can't do like Stop and Shop and the red Solo cups. We all understand that, but most of the kids that are coming here won't understand why they're getting a red Solo cup with candy in it instead of a drink. Most people wouldn't get that at all. And I can't use Stop and Shop brand because I just don't have any around me. We're going to do a projector with a wanted poster using a digital wanted poster that I will capture the images of trick-or-treaters who are coming up the walkway and put it on the wanted poster so it looks like the person who's coming to our house is wanted for some heinous crime. We'll do that. Might have we're in black now. Let's keep that right here and go here. How about that? We might have, let's see what else. Red and blue lights, LED lights on the other side of our deck just to give it some ambiance and some balance. I'm going to have a sound system set up and a microphone so I can, do a little radio bolo call out. I'll be on the lookout for a inflatable dinosaur, 4 feet in height, last seen on XYZ, headed this direction. I don't know. I won't give out addresses, but you can get 500 for 163. It's 163 friggin' dollars. I only paid $200 for the candy. I don't want to double the cost of the candy. 500 plain brown lunch bags for $12. I see I could do that, and then I could get like the evidence stamp red pen. That might be the best way to do it. Get the plain brown lunch bags, but I'm only giving them 3 or 4 pieces of candy each. And that's like a big bag and just a couple pieces at the bottom. And it's going to be, I think I might just have to do one big evidence bag and hand stuff out. I wanted plastic so you could see inside. That's super expensive. Yeah, I'd rather get more candy than pay to have a nice little bag for the candy in it. What happened to Boyd? She's just on timeout right now. She's right back over here. She just hasn't started. My neighbors do Jell-O shots for the parents. They make mini red Solo cups for that. That doesn't fit with the Recovery Addict theme of the live stream, but I hear you. Let's see. I have to get some crime scene tape to go around my flower beds that are lined with bricks at an angle, because every year we have kids trip over it, and I just don't want to get sued. We've just been lucky so far. We've repaired the sidewalk that had a little unevenness because we had somebody trip on that one year, even though it's not our sidewalk. We repaired it. Do the plastic snack bags. The snack bags would make sure we give everyone the same amount, so we don't end up giving up way too much in the beginning and then run out at the end. Hope it doesn't rain or you'll be stuck with lots of stuff. It might. but that just means the people who come get lots of candy. Kitty, member for 10 months, rarely chat. I watch on my TV, my favorite home for trials. This is the very best community. Kitty, thank you very much. Thanks for 10 months of support. Give out evidence bags every so many kids for the best costumes. I am getting links. 500 paper bags for $38. I think I can get a better deal than that. And the bags have to be tiny, right? Tiny. It can't be like a regular sandwich bag, or else it's too bulky. Uline has 4-ounce clear plastic goodie bags, 1,000 for $22. That's about where I'm at. But I don't know how I'd be able to print on them. See, that price range, that's right. Red, if you can send me the link to Uline on that one. I think I have a Uline catalog around here somewhere. It's missing. Who cares? I care because I have to have all the bags somewhere. And I can't be constantly shuttling, trays full of bags, because literally 600-700 trick-or-treaters if we have good weather. Evidence stickers, that's going to really increase the cost a ton. You got to realize candy is what? Between 6 and 20 cents a piece. Okay, if I'm doing small candy, I'm not doing big full-size candy bars. I'm not Mr. Beast. I just can't afford that. And so if the bag and the sticker costs more than the candy, I feel like I should have invested more in the candy. Walmart has 100 bags for $3. That probably sounds like a good deal. Probably get some from Sam's Club as well, but they might be too big. Holy cow. A ton of stickers, Halloween body bag decorations. Okay, I don't want them like pre-stuffed. I want to make my own body bags. Let's see if this is it. That's basically it, but I don't want to.
All right, have both parties had a chance to review the jury charge?
Yes, Your Honor.
The defense has as well, Your Honor.
Any objections?
No objection from the state.
Done from the defense, Your Honor.
We are getting evidence
Let's bring the
markers.
jurors in.
All right, for the jury.
And does anybody want a time?
She's gonna watch it.
We're going to do a chalk outline on the sidewalk as well. And maybe some blood stains or something. Some of these comments taken out of context sound terrible. Absolutely terrible.
Oh, please be seated. All right, everyone. I am sorry about our late start.
Yeah.
Our late start is due to things outside of our control with maintenance and the flooding that's happening in the building. I'm going to read to you the charge of the court. After I read the charge of the court, both parties, if they choose, will have a chance to give closing arguments to you. You do not need to memorize the charge that I'm going to read to you because you will be given the original when you begin your deliberations. Charge of the court. Members of the jury, the defendant, Shelby Jean Rodriguez, is charged in count 1 of the indictment with the offense of aggravated assault with a deadly weapon, alleged to have been committed on or about November 5th, 2023 in Bexar County, Texas. The defendant, Shelby Rodriguez, is charged in count 2 of the indictment with the offense of aggravated assault with a deadly weapon, alleged to have been committed on or about November 5th, 2023 in Bexar County, Texas. To these offenses, the defendant has pleaded not guilty. 1. Our law provides that a person commits an offense if the person intentionally or knowingly threatens another with imminent bodily injury. A person commits the offense of aggravated assault with a deadly weapon if the person commits an assault as defined above and uses or exhibits a deadly weapon during the commission of the assault. 2. Deadly weapon means a firearm or anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. Firearm means any device designed, made, or adapted to expel a projectile through a barrel by using the energy generated by an explosion or burning substance or any device readily convertible to that use. Bodily injury means physical pain, illness, or any impairment of physical condition. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. 3. A person acts intentionally or with intent with respect to the nature of her conduct when it is her conscious objective or desire to engage in the conduct. A person acts knowingly or with knowledge with respect to the nature of her conduct or to the circumstances surrounding her conduct when she is aware of the nature of her conduct or that the circumstances exist. 4. Self-defense. You are instructed that it is a defense to this prosecution if the conduct of the defendant was justified by law. A person is justified in using force against another when and to the degree she reasonably believes the force is immediately necessary to protect herself against the other's use or attempted use of unlawful force. The use of force is not justified in response to verbal provocation alone. You are instructed that the threat of force is justified when the use of force is justified. A threat to cause death or serious bodily injury by the production of a weapon or otherwise, as long as the actor's purpose is limited to creating an apprehension that she will use deadly force is necessary, does not constitute the use of deadly force. You are instructed that the defendant's belief that the force was immediately necessary is presumed to be reasonable if the defendant, 1, knew or had reason to believe that the person against whom the force was used was attempting to commit murder. Murder is defined as intentionally or knowingly causing death of an individual. And 2, the defendant did not provoke the person against whom the force was used. And 3, the defendant was not otherwise engaged in criminal activity other than a Class C misdemeanor that is a violation of a law or ordinance regulating traffic at the time the force was used. The presumption of reasonable belief applies unless the state proves beyond a reasonable doubt that the facts giving rise to the presumption do not exist. If the state fails to prove beyond a reasonable doubt that the facts giving rise to the presumption do not exist, the jury must find that the presumed facts exist. If the jury has a reasonable doubt as to whether the facts giving rise to the presumption do not exist, the presumption applies and the jury must consider the presumed fact to exist. Even if the jury finds that the state has proven beyond a reasonable doubt that the facts giving rise to the presumption do not exist, the state must prove beyond a reasonable doubt each of the elements of the offense charged in the indictment. A person is justified in using deadly force against another, 1, if the person would be justified in using force against the other in the first place, as set out above, and 2, when and to the degree the person reasonably believes the deadly force is immediately necessary to protect herself against the other's use or attempted use of unlawful deadly force. Reasonable belief means a belief that will be held by an ordinary and prudent person in the same circumstances as the defendant. Deadly force means force that is intended or known by the person using it to cause or in the manner of its use or intended use is capable of causing death or serious bodily injury. Bodily injury means physical pain, illness, or any impairment of physical condition, including death. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. A person has a right to defend herself from apparent danger to the same extent as she would had the danger been real, provided she acted upon a reasonable apprehension of danger as it appeared to her from the standpoint at the time. A person, 1, who has a right to be present at the location where the force or deadly force is used, and 2, who has not provoked the person against whom the force or deadly force is used, and 3, who has not engaged in criminal activity at the time the force or deadly force is used, is not required to retreat before using force or deadly force. If all 3 of these factors are met, then in determining whether such actor reasonably believed that the use of force was necessary, a finder of fact may not consider whether the actor failed to retreat. The defendant is not required to prove self-defense. The state must prove beyond a reasonable doubt that the defendant's conduct was not justified by self-defense. 5, count 1, aggravated assault with a deadly weapon firearm. Now, if you find from the evidence beyond a reasonable doubt that on or about November 5th, 2023, in Bexar County, Texas, the defendant, Shelby Jean Rodriguez, did use or exhibit a deadly weapon, namely a firearm, and Shelby Jean Rodriguez did intentionally or knowingly threaten imminent bodily injury to Anthony James Rodriguez by pointing said deadly weapon at or in the direction of Anthony James Rodriguez, then you will next consider whether the defendant, Shelby Jean Rodriguez, was acting in self-defense at the time and skip to paragraph 7. Do not consider paragraph 6. If you do not so find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant, Shelby Jean Rodriguez, not guilty of the offense of aggravated assault with a deadly weapon as charged in count 1 of the indictment, and proceed to paragraph 6 to next consider the lesser included offense of misdemeanor deadly conduct. Number 6, count 1, lesser included offense of misdemeanor deadly conduct. A person commits an offense if she recklessly engages in conduct that places another in imminent danger or serious bodily injury. Serious bodily injury, as defined in paragraph 2, applies and has the same meaning here. A person acts recklessly or is reckless with respect to the circumstances surrounding her conduct or the result of her conduct when she is aware of but consciously disregards a substantial and unjustifiable risk that the circumstances exist or the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the actor's standpoint. You are instructed that recklessness and danger are presumed if the actor knowingly pointed a firearm at or in the direction of another, whether or not the actor believed the firearm to be loaded. With regards to some such presumption, you are instructed A, that the facts giving rise to the presumption must be proven beyond a reasonable doubt, and B, that if such facts are proven beyond a reasonable doubt, you may find that the element of the offense sought to be presumed exists, but you are not bound to so find. And C, that even though you may find the existence of such element, the state must prove beyond a reasonable doubt each of the other elements of the offense charged. And D, if you have a reasonable doubt as to the existence of a fact or facts giving rise to the presumption fails, and you shall not consider the presumption for any purpose. Thus, with regards to the lesser included offense of misdemeanor deadly conduct under count 1, if you believe from the evidence beyond a reasonable doubt that Shelby Jean Rodriguez knowingly pointed a firearm at or in the direction of another, whether or not Shelby Jean Rodriguez believed the firearm to be loaded, recklessness and danger are presumed, and you may find as such. However, you are not bound to so find, and even if you do, the state must still prove beyond a reasonable doubt that each and all of this and the other elements of the offense of misdemeanor deadly conduct. And if you have a reasonable doubt that Shelby Jean Rodriguez knowingly pointed a firearm at or in the direction of another, the presumption fails, and you are not to consider the presumption for any purpose. Therefore, if you find from the evidence beyond a reasonable doubt that on or about the 5th day of November 2023 in Bexar County, Texas, the defendant, Shelby Jean Rodriguez, did recklessly engage in conduct that placed Anthony James Rodriguez in imminent danger of serious bodily injury, then you will next consider whether Shelby Jean Rodriguez acted in self-defense and proceed to paragraph 7. If you do not so find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty of the lesser included offense of misdemeanor deadly conduct under count 1, and do not consider paragraph 7, but skip to paragraph 8 to next consider count 2. 7, self-defense as to count 1. Keeping in mind the instructions on self-defense given in paragraph 4, even if you unanimously find that the state has proven beyond a reasonable doubt that the defendant, Shelby Jean Rodriguez, committed either the offense of aggravated assault with a deadly weapon, as in charge count 1 of the indictment, or the lesser included offense of misdemeanor deadly conduct under count 1, you must decide whether the state has proven beyond a reasonable doubt that the defendant did not act in self-defense with regards to count 1. Therefore, if you find from the evidence beyond a reasonable doubt that the defendant, Shelby Jean Rodriguez, committed either the offense of aggravated assault with a deadly weapon as charged in count 1 of the indictment, or the lesser included offense of misdemeanor deadly conduct under count 1, but you further find from the evidence that, or you have a reasonable doubt as to whether at the time she did so, 1, Shelby Jean Rodriguez reasonably believed or is presumed to have reasonably believed, as viewed from her standpoint, that Anthony James Rodriguez was using or attempting to use unlawful deadly force against Shelby Jean Rodriguez, and 2, Shelby Jean Rodriguez reasonably believed or is presumed to have reasonably believed, as viewed from her standpoint, that her threat to use deadly force with a firearm and the degree of threat were immediately necessary to protect herself against Anthony James Rodriguez's use or attempted use of unlawfully deadly force, and 3, Shelby Jean Rodriguez's threat to use deadly force with the firearm was not in response to verbal provocation alone, then you will find in favor of the defendant, Shelby Jean Rodriguez, on her claim of self-defense and say by your verdict not guilty of count 1. However, if you find from the evidence beyond a reasonable doubt that the defendant, Shelby Jean Rodriguez, committed either the offense of aggravated assault with a deadly weapon as charged in count 1 of the indictment, or the lesser included offense of misdemeanor deadly conduct under count 1, and you further find from the evidence beyond a reasonable doubt that 1, Shelby Jean Rodriguez did not reasonably believe and is not presumed to have reasonably believed, as viewed from her standpoint, that Anthony James Rodriguez was using or attempting to use unlawful deadly force against Shelby Jean Rodriguez, or 2, Shelby Jean Rodriguez did not reasonably believe and is not presumed to have reasonably believed, as viewed from her standpoint, that the threat to use deadly force with a firearm degree of threat were immediately necessary to protect herself against Anthony James Rodriguez's use or attempted use of unlawful deadly force, or 3, Shelby Jean Rodriguez's threat to use deadly force with the firearm was in response to verbal provocation alone, then you will find against the defendant, Shelby Jean Rodriguez, on her claim of self-defense under count 1. If you have found from the evidence beyond a reasonable doubt that the defendant, Shelby Jean Rodriguez, committed the offense of aggravated assault with a deadly weapon as charged in count 1 of the indictment, and have found against the defendant on her claim of self-defense, then you will find the defendant guilty of the offense of aggravated assault with a deadly weapon as charged in count 1. If you have found from the evidence beyond a reasonable doubt that the defendant, Shelby Jean Rodriguez, committed the lesser included offense of misdemeanor deadly conduct under count 1, and have found against the defendant on her claim of self-defense, then you will find the defendant guilty of the lesser included offense of misdemeanor deadly conduct under count 1. All right, ladies and gentlemen, if you'll just give me a moment, I'm gonna have you step in the jury room just briefly, and then I will bring you all back out. Everyone, please rise for the jurors.
I think she found an error in the instructions. That needs to be hashed over. A little bit confusing, but basically justified self-defense, that's okay. Unjustified, that's not okay.
All right, everyone, please be seated. So, please be seated.
It's okay, and
oh, sure.
Sorry.
All right, so as you all know, that in the courthouse yesterday, there was a sewage leak. My understanding, there was sewage on the first floor. Maybe it came from the second floor. Now there are other major leaks in the building. I don't want to say that I had continued to tell them there's a stench on the second floor. And attorneys who have been practicing for a while, you know, there was always the stench on the second floor. They sort of repaired it, but didn't repair it. Am I correct? No, they sort of repaired it. No, you can. So they sort of, oh yeah, you can. Well, this part is going to have to be on the record.
Right now?
Yes.
Okay, hold on.
Yeah.
Go ahead, Judge.
So as you know, they sort of repaired it and didn't repair it. So now this is where we are. They are shutting down the Justice Center because they say it is a biohazard. Now, when you put the word bio and hazard together, that is not a good thing.
Oh my goodness.
So is there any objection to, they're shutting down the Justice Center. unless there's somewhere else we can go, which I don't believe they have a place that we can go. I can call the district court admin and see if there's a place to go. Otherwise, the other suggestion is for us to continue this on Monday. So I want you all to discuss.
I have a suggestion, and on the record, operator, it doesn't make a difference.
Yeah, we're on the record.
The 288 district court is just down the hall, and it's in the Paul Elizondo Tower. I don't think they're actually occupying it today.
Well, let me
The whole
call.
building's
I
gonna shut
think
down.
like they're out. I don't think anyone's using that. Yeah, it looked like the door was closed. And I
All right,
didn't
so
think
we're
he was
gonna
there.
call, let me call district court admin to see if there's a court available. Otherwise,
Your Honor, just one thing.
Yes.
Where are the jurors gonna deliberate if we go? if
oh, they
there's a
have,
room?
they have a room.
Okay,
Yes.
I've never been, so I just.
Yes,
didn't
no,
know.
they have their, they have,
Yeah. Or the other option, I'm just gonna throw it out there. We have 2 impact courts, which I don't believe ever hold docket on Friday. They're also in Elizondo Tower.
let's see, let me call court admin and see what we can do.
The defense's thing, I'd like to see if we can get.
This is terrible for us, but it's sort of funny because we get to use this soundbite.
Your son just smeared feces all over my bathroom.
Yeah. Apparently there's a biohazard in in the Justice Center, and it stinks real bad. It's, the bad news of this, we're going to a courtroom that's not set up for Judge Boyd to live stream, which means we won't get a verdict and we won't get the closing arguments. That sucks. Bray, you might have to deliver your emojis right now. Right now. We'll hope. We'll hope. We can always cross our fingers and say, please just push it till Monday. We'll pick it up on Monday. But if they just pick up and go to another courtroom, we don't know that they have cameras set up, configured for a live stream like this. Let's just pretend there was a verdict, do a poll, and that will be our verdict. Breezes don't have to be okay. Here comes a flood of emojis. If you missed anything about this court case, which we sort of blitzed through and skipped around because we did have some audio issues where there was no audio for a while, Bree is going to deliver the story in emoji form. But this is how it ended. This is the last chapter, Tammy, for sure. Bree, make sure you get that. Oh, here we go. Here we go. All right. Oh my goodness. This part right here is quite telling. Okay, then kick him out. He leaves. He leaves on a work party. First, there's the they're married. They've got kids. They're happily married. They invite a third person into the relationship briefly. He leaves on a business trip. He goes a little drinking. Meets somebody. Unfaithful. Pinocchio knows. He had taken the ring off. Let's see. Talked about this. They went to the doctor, worried about an STD. Went to the checked to see if they had anything. Got injection of meds. Then there's an argument about it. A weapon may have been involved. More arguing. A pew may have been involved. Now we have somebody calls the police. They call the police on Shelby right there. And
all right, everyone, please be seated. So, ladies and gentlemen, the reason why I called for a break is because I've been checking the emails and keeping both the state and the defense informed of whether or not water is on the 4th floor. So water is not on the 4th floor. If water were to come to the 4th floor, I wouldn't say if or before waters even think of touching this floor, you all will be doing your deliberation not in the 187th jury room. We'll have a different place for you to do your deliberations. Does everyone understand? All right, so I'm going to continue reading the charge.
Yes.
8, count 2, aggravated assault with a deadly weapon, knife. Now, if you find from the evidence beyond a reasonable doubt that on or about November 5th, 2023 in Bexar County, Texas, the defendant, Shelby Jean Rodriguez, did use or exhibit a deadly weapon, namely a knife that in the manner of its use or intended use was capable of causing death or serious bodily injury, and Shelby Jean Rodriguez did intentionally or knowingly threaten imminent bodily injury to Anthony James Rodriguez by pointing said deadly weapon at or in the direction of Anthony James Rodriguez, then you will next consider whether the defendant, Shelby Jean Rodriguez, was acting in self-defense at the time, skip over paragraph 9, and proceed to paragraph 10. If you do not so find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant, Shelby Jean Rodriguez, not guilty of the offense of aggravated assault with a deadly weapon as charged in count 2 of the indictment, and proceed to paragraph 9 to next consider the lesser included offense of misdemeanor assault. 9, count 2, lesser included offense of misdemeanor assault. Now, if you find from the evidence beyond a reasonable doubt that on or about November 5th, 2023 in Bexar County, Texas, the defendant, Shelby Jean Rodriguez, did intentionally or knowingly threaten imminent bodily injury to Anthony James Rodriguez by pointing a knife at or in the direction of Anthony James Rodriguez, then you will next consider whether Shelby Jean Rodriguez acted in self-defense and proceed to paragraph 10. If you do not so find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty of the lesser included offense of misdemeanor assault under count 2 and do not consider paragraph 10. 10, self-defense as to count 2. Keeping in mind the instructions on self-defense given in paragraph 4, even if you unanimously find that the state has proven beyond a reasonable doubt that the defendant, Shelby Jean Rodriguez, committed either the offense of aggravated assault with a deadly weapon as charged in count 2 of the indictment or the less included offense of misdemeanor assault under count 2, you must decide whether the state has proven beyond a reasonable doubt that the defendant did not act in self-defense with regards to count 2. Therefore, if you find from the evidence beyond a reasonable doubt that the defendant, Shelby Jean Rodriguez, committed either the offense of aggravated assault with a deadly weapon as charged in count 2 of the indictment or the less included offense of misdemeanor assault under count 2, but you further find from the evidence that, or you have a reasonable doubt as to whether at the time she did so, 1, Shelby Jean Rodriguez reasonably believed or is presumed to have reasonably believed, as viewed from her standpoint, that Anthony James Rodriguez was using or attempting to use unlawful deadly force against Shelby Jean Rodriguez, and 2, Shelby Jean Rodriguez reasonably believed or is presumed to have reasonably believed, as viewed from her standpoint, that her threat to use deadly force with a firearm and the degree of threat were immediately necessary to protect herself against Anthony James Rodriguez's use or attempted use of unlawful deadly force, and 3, Shelby Jean Rodriguez's threat to use deadly force with a firearm was not in response to verbal provocation alone, then you will find in favor of the defendant, Shelby Jean Rodriguez, on her claim of self-defense and say by your verdict not guilty of count 2. However, if you find from the evidence beyond a reasonable doubt that the defendant, Shelby Jean Rodriguez, committed either the offense of aggravated assault with a deadly weapon as charged in count 2 of the indictment or the less included offense of misdemeanor assault under count 2, and you further find from the evidence beyond a reasonable doubt that 1, Shelby Jean Rodriguez did not reasonably believe and is not presumed to have reasonably believed, as viewed from her standpoint, that Anthony James Rodriguez was using or attempting to use unlawful deadly force against Shelby Jean Rodriguez, or 2, Shelby Jean Rodriguez did not reasonably believe and is not presumed to have reasonably believed, as viewed from her standpoint, that the threat to use deadly force with a firearm and degree of threat were immediately necessary to protect herself against Anthony James Rodriguez's use or attempted use of unlawful deadly force, or 3, Shelby Jean Rodriguez's threat to use deadly force with a firearm was in response to verbal provocation alone, then you will find against the defendant, Shelby Jean Rodriguez, on her claim of self-defense under count 2. If you have found from the evidence beyond a reasonable doubt that the defendant, Shelby Jean Rodriguez, committed the offense of aggravated assault with a deadly weapon as charged in count 2 of the indictment, and have found against the defendant on her claim of self-defense, then you will find the defendant guilty of the offense of aggravated assault with a deadly weapon as charged in count 2. If you have found from the evidence beyond a reasonable doubt that the defendant Shelby Jean Rodriguez committed the lesser included offense of misdemeanor assault under count 2 and have found against the defendant on her claim of self-defense, then you will find the defendant guilty of the lesser included offense of misdemeanor assault under count 2. You are instructed that you must not communicate with or provide any information to anyone or receive any information from anyone by any means about this case. You may not use any electronic device or media such as telephone, cell phone, smartphone, iPhone, BlackBerry, iPad, tablet, or computer, the internet, any internet service or any text or instant messaging service, or any social media platform, internet chat room, blog, or website to include, but not limited to, Google, Facebook, MySpace, Instagram, Snapchat, LinkedIn, YouTube, TikTok, Twitter, or X, to communicate with anyone, any information, or receive any information from anyone about this case, or to conduct any research about this case until I accept your verdict. Written statements made by witness to investigators or other officers or police reports made by officers and tendered by the prosecution to the defense for purposes of cross-examination are not part of the evidence unless introduced in evidence. Many times, statements and reports may be marked with an exhibit number, but are neither offered nor received in evidence. I can send only statements and reports received in evidence to the jury room. You are instructed that the statements of counsel made during the course of the trial or during the argument, if not supported by evidence, or statements of law made by counsel, if not in harmony with the law as stated to you by the court in these instructions, are to be wholly disregarded. You must disregard any comment or statement made by the court during the trial or in these instructions, which may seem to indicate an opinion with respect to any fact, item of evidence, or verdict to be reached in this case. No such indication is intended. You are instructed that the grand jury indictment is not evidence of guilt. It is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence, nor can it be considered by you in passing upon whether this defendant is guilty or not guilty. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case, which is not shown by the evidence. You are instructed that you are not to let bias, prejudice, or sympathy play any part in reaching a verdict in this case. After argument of counsel, you will retire to the jury room, select your own presiding juror, and proceed with your deliberations. After you have reached a unanimous verdict, the presiding juror will certify thereto by filling in the appropriate forms attached to this charge and signing his or her name as presiding juror. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given to the testimony, but you are bound to receive the law from the court which is herein given to you and be governed by that law. In order to return a verdict, each juror must agree to that verdict, but jurors have a duty to consult each other and to deliberate with a view to reaching unanimous agreement, if that can be done without violence to individual judgment. A unanimous vote means all 12 jurors must agree. Each juror must decide the case for himself, but only after an impartial consideration of the evidence with his fellow jurors. In the course of deliberations, a juror should not hesitate to re-examine their own views and change their opinion if convinced it is erroneous. However, no juror should surrender their honest conviction as to the weight or effect of the evidence solely because of the opinion of his fellow jurors or for the mere purpose of returning a verdict. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or other charged with the offense gives rise to no inference of guilt at her trial. The law does not require a defendant to prove innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charge beyond a reasonable doubt, and if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt after considering all the evidence before you in these instructions, you will acquit her and say by your verdict not guilty. Suitable forms for your verdict are attached to the charge for your convenience if you care to use them, but they are not intended to suggest to you in any way what your verdict should be, and you may or may not, as you see fit, make use of them. At any rate, your verdict must be in writing and signed by your presiding juror. Your only duty at this time is to determine whether the defendant is not guilty or guilty under the indictment in this cause, and you must restrict your deliberations to the issue of whether the defendant is not guilty or guilty and nothing else. After you have retired to the jury room, no one has any authority to communicate with you except the deputy who has you in charge. Do not attempt to talk to the deputy or anyone else concerning any question you may have. Instead, address your question to the court in writing. If you want to communicate with the court, notify the deputy. Any and all communications relative to the case must be written, prepared by the presiding juror, and submitted to the court through the deputy. Respectfully submitted, Judge Stephanie Boyd, 187 Judicial District Court, Bexar County, Texas. Suitable forms are attached. State, are you prepared to proceed?
We are, Your Honor.
All right, you may proceed.
Here we go with the closings.
Support, City Council. Good morning. We thank you for your time in this case. I know the judge just read a very lengthy document to you. You are going to have it with you when you go back, so don't feel like you have to memorize it or anything. But I did want to take the time to explain just a few things to you. On page 1, it talks about assault. And assault is when a person threatens another with imminent bodily injury. That threat can be with words, I'm going to effing kill you, or actions by pointing a gun at you or by thrusting a knife downward motion in your direction, okay? Next, I want to talk about deadly weapon. We had several witnesses testify that the gun in this case is a deadly weapon. It is a firearm capable of causing death and serious bodily injury. Same with a knife. A knife being thrust at you is capable of causing death or serious bodily injury. Serious bodily injury, as I said, can be caused by a gun, like the defendant said, and like our complainant said, being pointed in central mass, which is going to cause very serious bodily injury and potentially death. One thing I wanted to talk to you about are the mental states that were noted in the charge, intentionally or knowingly. That is not what you intended to do with the gun. That is not what you intended to do with the knife. It's what did you intend your conduct to be? Did you intend to raise the gun and point it? Did you intend to raise the knife and thrust it at Anthony? That's what that mental state goes to. Not were you going to shoot, not were you going to stab. Did you intend for your arm to raise and point the gun? Did you intend for your arm to thrust the knife? Okay. The other thing I'd like to talk to you about, we get questions about this all the time. The reports that the witnesses use to refresh their memory for their testimony, those are not going to go back to you. Okay, those were not entered into evidence. The only evidence that will go back with you is what was offered and admitted into evidence, okay? And you will have that with you back there. The other thing I'd like to talk to you about is credibility. That is directly within your purview. That's credibility of every witness that testified, including the defendant. She doesn't get extra points for testifying. You get to judge her credibility just like you would judge Anthony's, just like you would judge any of the officers that testified, okay? So next, I'd like to go through and simplify page 7 through 18. That was all of the counts, the self-defense, the lesser included, just to kind of make that a little easier. You look first to see if we proved count 1, aggravated assault with a deadly weapon by pointing a gun and threatening Anthony. If you find him guilty, then, if you find her guilty, then you determine self-defense, okay? If you say not guilty, then you go to the lesser included offense of deadly conduct, right? So deadly conduct is when you recklessly engage in conduct that places another in serious bodily injury and at risk of serious bodily injury. Kind of the same elements as ag assault, deadly weapon, but recklessness and danger are presumed if you knowingly point a gun at somebody, which we have here, okay? So again, determine if we've proven ag assault, deadly weapon. If you find her guilty, then you go to self-defense. If you find her not guilty, then you go to the lesser included offense. If you find her guilty of the lesser included offense, then you consider self-defense. Okay? And that's going to be the same for count 2. You determine if we've proven her guilty of aggravated assault with a deadly weapon by pointing a knife at Anthony and thrusting it in his direction. If you find her guilty of that, you go to self-defense. If you find her not guilty of that, you go to the misdemeanor offense of assault, which is going to be the same elements, pointing the knife at Anthony, okay? If you find her guilty of the lesser included offense, then you go to self-defense. So, have we proven all of our elements to you? I'm going to submit to you that we have. Not only did Anthony come up here and testify that they got into an argument, she was angry, she thrusted the knife at him, and when that wasn't enough, she went and got the gun and pointed it at his head and said, "I could effing kill you." That is aggravated assault with a deadly weapon. That is also deadly conduct. That is also aggravated assault with a deadly weapon with a knife. We have proven each of those elements to you, not only from Anthony's mouth, but also from the defendant's mouth. Because in order to claim self-defense, she has to admit to each of those elements, and she did. So let's talk about self-defense here. When you're just deliberating on whether she was acting in self-defense, I want you to think about credibility, okay? Consistency in her story. From that date of the offense, you're going to get that clip that we showed you back there with you. Please watch it. Listen to the words that she's telling the officers hours after this happened. Look at her demeanor in that clip. Look at her actions in that clip, okay? Look at the details she gives in that clip. Look at who has a motive to lie. She's facing some pretty harsh charges here. She does have a motive to lie. She has had 2 years of preparation to come up with what she put on the stand for you to judge. But let's just say, even if you do believe her story, I want to talk to you about apparent danger. Okay, apparent danger is something that is in the self-defense description. Basically, you don't have to wait for somebody to stab you before you try and take a knife away. So even if you believe her story, that they were this close together and she has a knife in her hand, in her right hand, and she's talking with her hands and she's yelling and they're fighting and she's angry, Anthony doesn't have to wait for her to stab him. He can go for that knife. He can try and defuse the situation. He was acting in self-defense, if you believe her story. Ladies and gentlemen, I submit to you that we have proven each and every element beyond a reasonable doubt. I ask that you find her guilty of aggravated assault with a deadly weapon in count 1 and count 2.
That was
All right,
short,
defense,
sweet.
what do you-
Runner, I apologize. You do reserve the rest of our time.
All right, defense.
Yes, Your Honor. And please report, counsel. Good afternoon, ladies and gentlemen. Thank you again for being here. I know we got off to a later start today than we had wanted. That's nobody's fault. But I know it's an inconvenience to all of you, and you have my appreciation for being here. We are here today, closing arguments, the state of Texas versus Shelby Rodriguez. Talk about burdens of proof. We talked about this in Vordaer. We're going to go into this more and more. Burden of proof is always on the state, and they must prove each and every element, all elements of an offense. And each element must be proved beyond a reasonable doubt. Most importantly, is that self-defense was not justified in this case. We are not denying that Shelby pointed a gun at Anthony Rodriguez that day. You heard her tell you that. The question is why? And the reason she did it is quite simple. She was in fear for her life, and her life was in danger. We showed you a few photographs, and you'll have these back there. Defense Exhibit 1, which we entered. The state didn't enter this, defense did. You see a Band-Aid on her arm, and you saw the wound when she took her blazer off to show it to you, right? You see a scar there. Happen when they're struggling for a knife. She gets poked or stabbed or cut. Then we have Defense Exhibit 2. Blood on the hands. It was documented, and thank God it was documented, because it lends credence. It proves what she was saying was true. She's sitting there, she's talking, they're having a heated conversation. She's not trying to stab Anthony. even says, I felt no real danger at that point. You know, she's across the counter, etc. At some point, he comes across, knife goes up, she gets her hand gets cut. She immediately goes for a weapon. Back the fuck off, is what she said. Pardon my language, but that's what she said. And why did she do it? It's quite simple. Her life was being threatened by a knife. You don't have to sit there and become a victim. You don't have to become a statistic. If somebody threatens your life, you have the right, I would say you have the duty to stand up for yourself, and that's what Shelby did. We talked about this before, just how high of a burden of proof it is. I can't tell you what number to place on beyond a reasonable doubt. All I can tell you is it's much greater than 50%. It's higher even than clear and convincing, which we talked about before. It's enough to take a child away from their parents. This is the highest burden of proof in the state, in the country. State has to prove this case beyond a reasonable doubt. Not only that aggravated assault happened, but more importantly, that this wasn't self-defense, and they have utterly failed in that measure.
They said utterly.
Again, as she stands there today, Shelby is presumed innocent. It is the only presumption that we have in a criminal case, right? And why is this important? Quite simply, it's because we don't make the accused prove their innocence. The state must overcome it, and they must prove that they're guilty. And more importantly, they must prove beyond a reasonable doubt that self-defense was not justified, that the use of deadly force was not justified. You measure it in the manner of what Shelby thought was reasonable in that time. And absolutely it was reasonable. I think anyone would say if you have a knife put up to your neck and you have a firearm available, you're going to go for that firearm. You're going to go there to help diffuse the situation, to protect your life, to protect your liberty. Anthony's on a mission. You say he didn't feel threatened by Shelby with the knife. She's across the counter. State wants you to believe that she's somehow making a stabbing motion. You heard Shelby talk. She had a knife in one hand. She had a towel in the other. They're doing the dishes, right? Just because somebody's holding a knife, you're doing the dishes, this doesn't give you justification to think that your life is in danger and threatened, right? There was no threat there. She simply has the knife. She has the towel. Quite frankly, she was forthcoming on the towel. She didn't say it on direct examination because I didn't ask it for her, okay? And I'll tell you this much. If there's ever something that I did wrong, something that you didn't like that I did, I'll accept that. But I ask you, don't take it out on my client and don't hold it against Shelby. After all this, you're going to have a chance to talk to all the attorneys, critique us, give us any advice that you have for us. But again, if there's something that I did that said to offend you, you didn't like, please, please, please don't hold it against my client. Again, Anthony's on a mission. He didn't feel threatened. That negates and disproves count 2 right there. In count 1, she was absolutely defending herself. You saw the blood on her hands. Keep in mind, these photos were taken hours later. She told you she had cleaned up. She was able to address her wounds. She was able to do this. Yet there's still drops of blood residual there. And again, thank God we have these photos because it shows and it proves what really happened that night. Again, you saw the defense enter this. This didn't come from the state because they knew it would destroy what was already a flimsy case. If you were on the fence, this absolutely puts a nail in the coffin. It shows that what happened this night was self-defense. Let's talk about what makes sense. By testimony, you have 3 hours. I think 2 hours and 45 minutes, 2 hours and 50 minutes. Again, we're talking something 2 years after the fact. We're not going to have exact timelines. But about 3 hours elapse, and Anthony doesn't call the cops. He says he doesn't know what to do. Folks, a child learns to dial 911, and a man with a master's degree certainly knows what to do. I have a 10-year-old niece. She knows. You call 911. If there's trouble, you call the police, right? You're mulling around for 3 hours. You're not sure what to do. Secondly, or lastly, we have it. Anthony's an admitted wife beater. We're going to be blunt about that. The incident happened years ago, but he slapped her. I don't know about you. I've never even thought about hitting a significant other. It's reprehensible to me. Family violence, unfortunately, does happen. This was not a happy marriage. This was not a healthy marriage. This was not healthy in any way or regard. But think about what that means and what it does to the credibility. You heard the prosecution say that you are the judges of credibility, and that is 100% correct. It is up to you to decide to believe any and all witnesses, one of them, none of them, it's up to you. And that is a great responsibility and a great power that you have. What does this admission do, and what does it do to the credibility of Anthony Rodriguez? Again, he says he never calls the cops. He calls his mom. Then his family calls the police. And he said he's so afraid for his life that he was on his knees. According to Anthony, he leaves the house and his 3 children with someone that he wants you to believe was threatening to kill him. I don't know if any of you are parents. You have nieces, nephews. I don't have kids, but I have a niece that I adore. She's my entire life. If I thought for a second that she was in the slightest bit of danger, I would give my own life before I left her in a situation. Yet he's going to leave 3 children behind. Why is that? Because there was no danger. Shelby wasn't the one that was the aggressor. She stood up for herself. She stood up against an assault, and Anthony got caught. So why leave 3 kids behind? Because he knows that she's not crazy. He knows that she's not in danger. And again, 3 hours nearly elapses. Ask yourself what's reasonable in this case. And again, who in the right mind would leave any child behind? My apologies.
Thirsty.
You have 3 hours of time, plenty of time to call the cops, gather your children, and get out. Who cares about a bag at that point? You get your kids, you get out. You call 911 immediately. There was ample time to do this. You heard that the gun was put back in the cabinet. You go to the backyard, you grab your kids, you run to a neighbor's house, you do anything. You don't sit around and wait for 3 hours and mull it over if you truly think that your life is in danger. Shelby didn't call. And why is that? Because the danger left the house. The incident's over and her kids were safe with her. Again, Anthony didn't call the cops because quite simply he knew that he did wrong. Shelby fought back, and that is the only thing that is supported by the evidence in this case. You have the photographs of blood on the hands. You have Shelby telling you what happened. Knife went up to the throat, hand went up. The whole incident, she said, took about 10 seconds. That's probably right. It may have even been less, right? It happens in a flash of blink of an eye, but that's how quick it can take for somebody to lose her life. And Shelby absolutely defended herself the only way that she could have, and that is with the firearm. Thank you, ma'am. You have 3 possibilities in this case, and I'll tell you. And you got to forgive me if we were having technical difficulties, normally in animation. You have guilty verdicts. And let me explain kind of what you're looking at here. I don't know if you ever are horse racing fans or dog racing, but you have a horse that's so far out ahead of the pack, that's not even close. We asked you who won the race. It's this horse right here, about 200 yards ahead, right? That's guilty. No question. You have not guilty. And then we have something we call not sure. Right here, you ever heard, finish by a nose, flash finish, you're not really sure who may have gone there? Not sure is not guilty. Any doubts that you have go to the benefit of the defendant, not to the state. But folks, I'm going to tell you, I don't think you have a doubt. I think it's pretty clear what happened here. Again, I'm going to tell you, we're not disputing that Shelby pulled the firearm on Anthony. In fact, I'm grateful that she did, because what she did was the only thing she could have done to defend her life in that moment. She was threatened with deadly physical force. You saw the blood marks on her hand from the cut, and she defended herself the only way she could have. Ladies and gentlemen, last but not least, I want to end how I started this whole process and say thank you. Sincerely and very much thank you for your time, your patience, and your consideration throughout this whole process. Ultimately, we'll also thank you for your verdict. And I hope and pray that y'all reach the right decision, the only decision which makes sense, and that is not guilty. Thank you very much.
All right. We've got our poll up right now. If you haven't voted, hurry and do so.
You have 8 minutes and 16 seconds.
8 minutes, 16?
Yes.
Ladies and gentlemen, I want to address something right at the beginning.
I want you to focus on why you are actually here. You are not here to decide whether or not Anthony Rodriguez is a good or a bad husband. You are not here to decide whether Anthony Rodriguez is a good or a bad father. Okay? Yes, he's cheated. Yes, he sinned. Morally and ethically,
sinner.
He broke his wife's trust. That does not give her the right to threaten his life, though. Okay? Focus on why we're here, to decide if an aggravated assault took place. So let's talk about how, indeed, an aggravated assault did take place. Okay? Like my co-counsel said, pointed a gun at his head, threatened to effing kill him, had a knife, stabbing towards him. Both of those are aggravated assaults. Next, you have her own words from that day. The clip that we showed you, that you guys can go and take back to the jury room and watch. What does she say that day? Her words, I want the fucking truth, because he had been lying. So yes, I was like, I'm going to get my gun and I'm going to point it at you. I screamed at him and yelled at him and told him to get the fuck out of my house. Her words, right
That
there.
pretty much
Aggravated assault, both counts.
No, that doesn't say both
Let's
counts.
think how reasonable people act when they're in the heat of a moment. What do? As soon as they're having to bring this incident up, they spew out everything that's on their mind right there and then. You all know it. You're all reasonable people. We all get angry every now and then. Our anger is still at such a high level that whatever just happened comes out, the truth comes out. And then you're like, wait a second. What did I just say? Let me back up. Let me rethink what I have. What did I say? What came out of my mouth? Well, that's exactly what she did. Look on this video clip.
I told him I want the truth because he's been lying. So yes, I was like, I will get my gun and I will point at you. And I screamed at him and I yelled at him and told him to get the fuck out of my house. Because it's not loaded.
It's not loaded. That right there is her knowing that she was caught. She was caught, and she had to rethink right there. What sounds better for me? What sounds that makes me sound less guilty? The gun wasn't loaded. That came to her mind, as if that makes it better for her, right? She got caught, and she tried to correct herself. Let's also talk about her claim of self-defense. All right. So her story is that they were in the kitchen. She had the knife. He was close to her because, in her words, he lunged at her. She had the knife in her right hand, and he grabbed it and put it to her neck. Let me stop right there, because so far I'm confused. Because yes, in defense's own exhibits, you're going to see, on this picture, where's the mark on her neck from this knife? He admitted there was no mark on her neck. That's for you to decide. You guys judge credibility, okay? But in continuing in her story of that, with the knife in her right hand, backs off a little. With that same hand, she reaches up and over a 6-foot fridge, opens the cabinet, and gets her gun with the same right hand that she said. Again, you decide credibility and if that makes sense. Also consider the fact, what the co-counsel just said, she has had 2 years to get her story straight, to tell you something that makes her sound less guilty, makes her sound more credible. Who's credible and who's consistent? Anthony Rodriguez is consistent. Okay? Well, how do we know he's consistent? Well, defense tried to trip him up on cross-examination. He stuck to his story. He gave an interview with the first responding officer. You heard Detective Carrion testify. His job is to review the initial statement In the responding officer's report, he then scheduled an interview of Anthony Rodriguez, and you heard Detective Curran testify. He was consistent. Consistent, inconsistent. Keep that in mind. Okay? Let's talk about her claim, what she said, what she wants to be with her children.
To run out of
And
time,
I don't
dude.
blame her. All children should have both parents in their lives. But her idea of the best way to defend herself was to pull a gun. Her own life in her mind was at stake. But what about the lives of the children? She's got a loaded gun there within the immediate vicinity. Why was she not thinking about that? Okay. Let's move on as well.
2 minutes.
Thank you, Your Honor. What did we talk about during jury selection about proper gun safety, gun handling? We all agree you do not ever point a gun at someone unless it is your intent to use it. Thank God she didn't, because it takes that quick of an impulse to do so, and things could be very different right now. Thank God she didn't do so. Okay? That still does not excuse her behavior, though. Okay? It still does not justify her actions. Her actions must be held accountable. Okay? That's why the laws are in place, ladies and gentlemen, to hold people accountable. Keep the community safe, keep the public safe from acts like that. Okay? Because of that, you have to decide. I'm not asking you to decide that she's a bad person. I'm just asking that you tell her that what she did was not an appropriate response. Hold her accountable. Protect the public, protect its citizens. Because of having found and proven that she has been committed these two crimes, what you need to do first, then when you get back to the jury room, is say which one amongst you is going to be your presiding juror. Once you have selected your presiding juror, you begin deliberations, and it should be easy. Again, easier case than you think. Do not make it any more complicated than it needs to be. But you're going to get this verdict form. Okay, that's in the back of the jury charge. You're going to go down and say verdict form. You're going to circle guilty. Presiding juror signs right there. Count 1. Count 2. Same thing. Aggravate assault with a deadly weapon. You're going to circle guilty. Presiding juror sign. Done. Tell her this is not acceptable. We cannot have this in Bexar County. Thank you all so much for your time today.
All right, we're going to close out the poll.
Ladies and gentlemen, Deputy Laura is going to take you to the back. And I'm going to ask the two.
So let me tell you what I understand the problem is at the Justice Center right now as to the biohazard, which if you missed this, the judge made an announcement. There's a biohazard issue at the Justice Center, and it is this. The exit pipe, and we're talking sewer, from the Justice Center, there's a no-flow situation happening. I don't know if the blockage is outside the Justice Center or inside the Justice Center, but nothing's going out. We are on the 4th floor, and as we have learned from every crappy job we've ever had in our lives, poop rolls downhill. So the people upstairs that flush, it's working fine. It just goes down and then builds up. It has built up to the 3rd floor, and it might get to the 4th floor today. I'm sorry. When they say we don't have water on the 4th floor, water is being generous. Water is, we're talking black water. We're talking sewage. What floor is it coming out on? Anyway, so 3 floors worth of blocked up pipes. stop. They're not going to, they're flushing still. The jury's taking a break. They're like, bathroom's working fine for me. Somewhere downstream or down building is, has an issue. And it's just building pressure. Anyway, that's what's happening for the jury deliberations. I think they want to make it quick. They want to get out of there. There was a smell on the second floor. There's always been a smell on the second floor, apparently. Can't make this stuff up. You can't. All right, let's do a quick check here and see. We are now in verdict watch. I guess we can start the verdict watch counter, right? Should do that. There we go. And now, what does it look like? Oh, it's terrible. Okay, I'll adjust it a little bit. Give me a second. We'll put the clock on the screen, and then we'll be able to do a little court hopping while we wait for the jury to make a decision, which I think is going to be pretty quick, honestly. Personally, I think she might be found guilty of assault with a deadly weapon as it relates to the gun, but possibly not guilty as it relates to the knife. There we go. There's our timer. And we'll just move that down just a wee bit. Right? Oh, that's too far. Does that work? Oh, that's too much. And crap a little bit off the top. Actually, we'll put that on there. Verdict watch. There we have our own label. All right. Please don't make a song about poop in the courthouse. Yeah, I don't think I will. We are in verdict watch. I'm getting a cold, guys. I'm not sure what I did to catch a cold. I hope I didn't get it from Judge Middleton's courtroom, because that's not a cold. But anyway, let's do a quick check here and see if we have any other courts we can jump to. Judge Middleton is now doing landlord-tenant matters, and it's busy.
The 10th of October, which hopefully won't be as bad as today was. In fact,
Can I ask
nothing.
a question?
Yes.
Can I evict just her?
What?
Not very simply.
What did
You
I
could
pop in
evict both and then execute a new lease with him.
Okay.
But let's set this for next Friday. Looks as bad as today.
Rebecca in the
Ms.
corner on the
Richmond,
bottom.
I'm not sure whether you're.
It is what it
I
is.
got a bunch of civil stuff. You're here at 11. So let's continue this to 10:50. Friday, October 10th.
Okay.
She could be facing between 2 and 99 years.
At what time, Your Honor?
10:50 a.m. And tell her she needs to get in here on that insurance case.
Yes, I will relay the message to her.
Okay, we're going to see if there's anybody else we can...
Yeah. I guess there's a lot of things I wasn't aware of.
Yeah, there was a lot of things. All right, let's see if there's anybody who's not doing landlord-tenant that we can pop in on briefly. Live on Patrol is doing their thing. That's nice. We've got a little hey diddy diddy going on. Let's see what else. Judge Raquel West, that was yesterday. Judge Mercer had some first appearances. Let's see if we can take a look and see what he had going on.
Corporal, I think a camera may have got knocked off a little bit. We can barely see Mr. McDaniel. If it needs to be shifted to your left when you're facing the camera, not zoomed in, but yeah, that's better. Thank you. I can see it. Whoa.
Right about there?
Yeah, that'll work. That'll work. Thank you. Richard Smith is next. Actually, I think Mr. Smith, I got a text, Mr. McDaniel, from you saying that he was not going to be participating in the first appearance.
Yeah, it is not. He's just going through some issues. I let him know there's going to be a hold up on, and I'm going to let Elizabeth Simpson know where he's at, and we'll just have to go ahead and first appearing.
Perfect, Mr. Mitchell. Anything?
I think all we need to do is just give him his pretrial date.
All right, thanks. Sounds good. So it is no bond on that warrant, and his pretrial looks like it's going to be October 21st. And thank you, Mr. McDaniel, for notifying his attorney. The next case we have is William Bauer. Bauer, good morning, Mr. Bauer. You're here because you've been accused of 1 count of aggravated assault on a law enforcement officer, 1 count of resisting an officer without violence, and 1 count of approaching a first responder with a specified intent after warning. Those second 2 charges are misdemeanors. The first one's a felony charge. And Mr. Bauer, as far as I can tell, you're entitled to a bond. There is probable cause in the complaint. I'm going to listen to the attorneys before I set your bond, sir. Mr. McDaniel, anything?
Nothing, Your Honor.
Mr. Mitchell?
Nothing at this time, Your Honor.
Mr. Bauer, that I'm going to set you the normal bond I would set for these charges. That third-degree felony bond's $5,000. The other 2 are misdemeanors. Their bond will be $2,500 each. You have a total bond of $10,000, but it's cash or surety. Cash or surety, Mr. Bauer, means you do not have to come up with all that money. You can go through a bondsman. That's what a surety bond is. And you'll get a chance in just a few minutes, sir, to post that bond by using the telephone, call whoever you wish. Mr. Bauer, you do have a court date of November 4th at 8:30. The jail will give you a written notice. If you post bond, they'll give you that notice before you leave the jail. Mr. Bauer, you will not get a notice in the mail. That notice they put in your hand will be the only copy you get, so make sure you show up for that court date. Mr. Bauer, do you have any questions?
No, sir.
All right, sir. Wish you the best.
Thank you.
Darla Simcoe. Ms. Simcoe, good morning. Ms. Simcoe, you're here for first appearance accused of 1 count of trafficking in methamphetamine, 1 count of possession of methamphetamine with intent to distribute, and 1 count of possession of drug paraphernalia. Ms. Simcoe, there is probable cause in the complaint for these charges, which I know allegedly occurred about a month ago. Ms. Simcoe, a little less than a month. Ms. Simcoe, as far as I can tell, you're entitled to a bond. But I will listen to the attorneys before I address that bond. Mr. McDaniel, anything?
Your Honor, I would just, ask for a couple issues, I guess. Issue number 1, it appears like this is based primarily, if not exclusively, on the smell of marijuana. And I know there's new case law on that, but there's also older case law, that has to be pieced together about it. Also happened in September, and I'm not sure why the deputy who wrote this complaint then went out there and arrested her at her house, and it's been a month and has never asked for a warrant on the case. So there is a presumption that anytime that you take items from someone or arrest them, or essentially you take someone, there's a presumption that it's unconstitutional unless the complaint has enough information into it as to why the taking was constitutional. And I'm not sure if the complaint even just basically based on the smell is enough. But then to go out there and arrest her a month later at her house without getting an arrest warrant creates some issues, I guess, Your Honor.
Mr. Mitchell.
Yeah.
Nothing at this time for first appearance purposes. I'll keep it like that.
So, Ms. Simcoe, I'm not aware of any law. There isn't a law that requires a warrant if the officer has probable cause that the felony's been committed. Under the old system, the state attorney's office liked to review warrants. I review cases and they would ask for a warrant. This kind of case, anything more than a day old, that changed probably a month ago. The state attorney's office no longer requests to be involved in the warrant review process. So sometimes officers don't get warrants if they don't have to. I disagree with Mr. McDaniel. Mr. McDaniel, if there's some case law, I'd love to see it, but I don't think an officer has to get a warrant if there's probable cause for a felony. Secondly, at the time this stop was made, the law is different than it appears to be today because Mr. McDaniel provided us a case that was issued 2 days ago from the Second District Court of Appeal that reverses their opinion from the Owens case, which was the end of last year. So before 2 days ago, there was a split among the district courts of appeal on smell of marijuana being the basis for a search. That appears to be no longer the case after 2 days ago. However, even now, even after 2 days ago, smell of marijuana cannot be the sole basis for the search. And there are other bases for this search that the officer alleges, specifically the officer alleges that you admitted someone had been using marijuana in your vehicle. That's what the complaint alleges, ma'am. And that is a separate additional basis in addition to a smell. So I think there's clearly probable cause. I'm going to set you a bond of trafficking that normally would set for the amount of $50,000. Possession with intent to distribute will be $15,000. Possession of drug paraphernalia will be $2,500. Your total bond, Ms. Simcoe, is $67,500 cash or surety. You have a condition of random urinalysis. Ms. Simcoe, if you do post the bond, ma'am, you have a condition of random urinalysis. That, ma'am, you can be aware that you're probably going to be drug tested at some point. So that's going to happen very likely. You're also going to get a notice for your court date, which will be November 4th at 8:30. And you're going to get a chance to use the phone in just a few minutes, ma'am, to try to post the bond. Lastly, I am taking into account your criminal history, which is very lengthy. Ms. Simcoe, do you have any questions?
Yes, sir.
All right, ma'am. Wish you the best. Taryn Hussey.
There's a name.
Ms. Hussey, good morning. Ms. Hussey, you're here because you've been accused of one count of methamphetamine, possession of methamphetamine, one count of possession of cocaine, one count of possession of drug paraphernalia, 3 charges in total. Ms. Hussey, I've read the complaint in your case, and Mr. McDaniel provided Mr. Mitchell and myself a case from 2 days ago, dated October 1st.
It's Williams v. State.
Which would have been 2 days before the arrest. That may be relevant in your case. So I'm going to ask that you listen to Mr. McDaniel and Mr. Mitchell, and then we'll see where we go from here. Mr. McDaniel.
Your Honor, going back to the presumption, there's a presumption of unconstitutionality when you search someone without a warrant. And, and in this case, it's on the officer to provide enough information that would create a probable cause. And essentially, it appears the probable cause is based solely on the smell of marijuana, or if not solely, it's nothing else in there really brings anything to a probable cause that the items that they was in there searching for were there. Nothing to bring to that level.
Thank you, Mr. Mitchell.
Just a moment, Your Honor.
If that's the case, the prosecutor should move to dismiss. If that's true.
Nothing from the state at this time, Your Honor.
So I'm not real clear. I called our law clerk this morning for some guidance on when in the October 1st, Second District Court of Appeal becomes final. And it really, in the bottom of the opinion, it says there's some language in there about finality at the very end of the opinion you sent, Mr. McDaniel, and that just confused me even more. So what's clear is the way that I've been reading this, because there was a split, at least before October 1st, between the District Courts of Appeal in Florida. What's clear is that you even by the most law enforcement friendly opinion, you had to have something. Well, no, that's not necessarily true. The way I've been reading those cases is you needed something besides smell. So my question is, what did he have other than smell, he being the officer? And what the complaint says is this. He had odor marijuana, allegedly, what he thought was marijuana. I asked her if there was CBD, hemp, or marijuana inside the vehicle. She admitted her friend sometimes left such items in the car and pointed to a package of zigzag cone wraps. The problem is, in his question, some of the items in his question are legal, that being hemp. So basically he asked her, are there any legal or illegal items in your car? And she doesn't answer it specifically, at least not in what he put in his complaint. Instead, she said, sometimes my friend leaves some of those things in my car. So does that, coupled with an odor
Nope.
that is either marijuana or hemp, based upon the law I'm reading, give him probable cause to search? And I don't know about that. Mr. Mitchell, what's your thoughts?
I'm of the same mind. I'm not entirely sure about it either.
Mr. McDaniel?
I think there needs to be more in it. I mean, obviously, I guess, and if you're, so if you take out the smell of the marijuana, and that's an action that can be used on something else, would just that other issue that he brought up be anywhere close to probable cause? And if it's nowhere close to it, would just the smell of it raise it above probable cause? I think the answer to that would probably be no, based on those answers and the questions he asked.
Move to dismiss.
I just find it hard to believe that was his exact question and that was her exact answer, because if it was, there would have to be a follow-up question. He would have to clarify. It doesn't make sense if she says there's some things in here that are legal. Essentially, that's what she'd been admitting to without some follow-up questions. I don't think that's it's not very well articulated at all. And I think in that kind of situation, I agree with Mr. McDaniel. Without the smell of marijuana, the rest of it's not even close.
Yep.
Now, the smell of marijuana can get you there, but it's got to have something to go with it. And I just don't think that's not enough, because he didn't ask the right questions or put the right answers down. Or if she gave them, he didn't articulate them in the complaint. So I'm going to find no probable cause on these charges. Now, that doesn't mean the case is dismissed. What it means, Ms. Hussey, is that if the state attorney's office and law enforcement can correct this, ma'am, by filing an amended complaint, they very well may. And that'll be up to them to try to do that. Hopefully there was a camera on. Hopefully the officer had a camera on, and the state attorney's office can see exactly what question or questions you were asked and exactly what your answers were. And if there's additional evidence, or if the state feels like they want to, if it's exactly what the officer put in the complaint and the state wants to have that heard before Judge Garcia, they certainly can do that by filing the information against you. But for right now, I think this officer missed the training that we did back in March or April. We covered this specifically in a training then, and that officer wasn't at that training, so I don't think he has been brought up to date with this changes in marijuana law that's happened in the last year and a half. So there's no probable cause today. You're going to be released from custody. I need to make sure that we've got an address for you, because if the state does charge you with an information, I want to make sure you get your court date. Is it the Dean Road ad?
Yes, sir.
Make sure you check your mail so that you don't miss your court date, ma'am, if the state does charge you. Ms. Hussey, do you have any questions?
No, sir.
Wish you the best, ma'am.
Immediately, the defense attorney mutes the mic. Don't say anything that could get you in trouble. Look, you're winning. You're winning. Be quiet.
Mr. McDaniel, that's everything I had on my list. Anything else with the public defender's office?
No, Your Honor.
Corporal, anything else from the jail?
No, Your Honor.
And Mr. Mitchell with the state attorney's office.
I think Ms. Hussey's case is going to be Ms. Harris's case going forward.
Okay, we're done with that one. Let's play Guess the State based on the accent of the judge. Nope. Guess who just shut off their live stream? That would be Judge Boyd. I think she just started it again. Let me just check and see.
And threatening Anthony.
Hang on, let's go back here. One second. Okay, that was our closing arguments. She just barely killed the live stream.
If you find him guilty,
Yeah. That's the closings we just heard. Wait for it.
Do y'all need the exhibits out for your closing?
I don't.
It says she's live, but it ended just now, so we have to wait for her to start a new one. All right, where are we? Here we are. Howdy, people. Sorry, I've been a little bit sidetracked today, just a tiny bit. Does Judge Boyd know we watch your stream? Nems Girl, she should. We sent her flowers and a note, thank you from the channel, and she had them in her. We watched them get delivered live. So yes, I would say yes. She knows. Let's see. I've been shopping for Halloween stuff. Let me tell you what I've got in my cart so far. Ready? Here we have a projector, a rear projection screen. That's like a sheet that can be lit from the back instead of the front. So the projector could be on my deck and it will shine out in the yard. A fog machine with fog juice. 1,000 feet of crime scene tape. Evidence markers. That's what I've got in my cart so far. Fog juice, yeah. The good stuff. We've got the evidence markers. I think evidence markers come with some not doing any trial specific stuff like Stop and Shop or Red Solo cups, because no one will get it unless they're true crime addicts, and most of these kids are not. So it just won't make sense. But don't order items till Prime Day. Might be on sale. Nope, I'm ordering them now because they're going to be sold out. That's what I'm going to do. Don't forget the cables. I have plenty of cables. Get extra fog juice. It goes quickly. I got a gallon of fog juice. I think that should be enough for one night. Body bag. I am looking for a body bag. I'd like the morgue style, but I don't like the one that says City Morgue on it. So I'm still looking for a body bag. Ashley, listen as we drive to Tennessee. Don't speed. You can get hazmat suits at Home Depot. That's the other thing I need. Let me look. I think Lowe's had them as well, but I'm seeing if they're cheaper online. So let's see. A Tyvek suit. Medtex hazmat suits. Disposable. I need like a CSI one. What does it say on the front? Looking, hang on. Nope. Okay, I'll try to find one that has a sticker on it or something. You heard frog juice. Very different. Good fog juice comes from Froggy's Fog or Guitar Center. I was recommended Fogworks. Very dense fog, long lasting. I wonder what Mrs. Ari thinks about this. She laughs and shakes her head. Let's see. Yes, Mr. Frog did make an appearance. Oh, Lindsay, you missed it. He made an appearance, and he's out on a PR bond, believe it or not. If you get the hazmat suits, don't forget the safety goggles. We'll have some safety goggles as well. Did you get liquid blood? I did not. I don't want to make a mess on other people's costumes. Let's see. Groovy Cheryl, I can show you the link to it, but we generally don't go back and replay courts that we followed already. It's still up on the live stream. All my live streams are available to rewatch. Test tubes, evidence kits, old school toolboxes. I'm thinking a table with a couple items like that with a little bit of red blood and stuff on it might be good as well. White tablecloth, red blood. There's a frog playlist on the channel. Thank you very much, Red Pen. Corn syrup and red dye for the blood. I want washable. Red dye is not washable. That's my concern. I do special effects makeup. Want your face to look like you ran into a wall. I've had Hollywood grade makeup done on me before for a gore this was a fire injury, burning blisters and everything. That was pretty interesting. Do you have a microscope? I do. We have a microscope here. Send a link to the burner for 1,000 3-inch biohazard specimen bags. Alex, this sounds perfect. Let's see. Locking bags. Okay. It's still 3 by 5. That might be work. That might work. This might work. They're pretty cool. They look like, you know, biohazards. That might be one that we can use. The price is right too. You have a microscope out there for crime scene analysis. Contact your local coroner. They may have a body bag they don't use anymore. No, thank you. No, thank you. I don't want a real one. Okay, one of the best Halloween houses I took my kids to for candy had speakers up in the trees, and they played a chainsaw on loop. It was hilarious. I put speakers on the sides of my stairway, headed up from my sidewalk to the front door, where we have our stone lions. The lion statues and the speakers go up there, and then I wear a wireless mic and I run it through a sound effects machine so it does sort of freaky noises and stuff. Renee Williams, Spirit Halloween, NA's body bags. Check online. I might have to do that. Spirit Halloween, the stores pop up all around here, so maybe I'll see if I can find one. Interrogation lamp. We're gonna do possibly. I'm looking for a good black light, maybe like black light LEDs that can shine and illuminate the sidewalk, where we will have some chalk that we have drawn some body outlines on the lawn with, or on the sidewalk with. Let's go back to the channel. Judge Boyd is not live currently. So I will do sound effects for sure. I just can't play music on the live stream or else I get a strike. Let's see. It's diabolical. It is. I think that's it. Should we go to lunch? Should we take a lunch break? I'll just be shopping. But we know what you'll be doing this weekend. Yeah, most of the stuff will arrive today or Monday, I think. I need some rubber gloves. What crime scene gloves? Should I go black, blue? What's the color for the gloves? This morning, I think you said you had an announcement about the channel, but then I missed it. Can you fill me in, please? Rachel B., it's our Halloween plans. We're going to definitely live stream the trick-or-treating because I tend to live in the one place in the world that still has a ton of trick-or-treaters. And by a ton, I'm talking 600 last year. 600 people came to my door last year. And so, as a lot of people enjoy Halloween, but either don't have the opportunity to give out candy, or people don't come around anymore, or it's just not feasible for one reason or another, I'll share my trick-or-treaters with you. So, let's see. The other jewels. Oh no. Oh no, I'm so sorry. We're looking at a transmission issue on our car as well. That is never fun. Blue nitrile gloves looks the most evidency. Okay, we got a box of those.
Texas, Adam Hood and Amy Owens, who were defending Your Honor.
All right, have both parties had a chance to review the...
Wait, no, we just heard that already. Why did it just jump back to that? Judge is not live. That was just the Computer going nuts. You can make a body bag with black trash bags. That might be a little much for my wife to agree to. We're not into a lot of the gore. I might be able to swing a severed arm or two, from those foam arms. Mary, I don't know yet. We've got a couple coming up next week. We've got our eye on. As always, we try not to announce it until we know that it's actually going to happen, because so much changes in the last few minutes, and we get a lot of angry people when we tell them we're going to have something and then it just doesn't happen. The more elaborate your house for Halloween, the more kids you'll have next year. Word will get around. This is my neighborhood. My neighborhood, the word gets around. This is where you come to trick or treat. Go to local dry cleaners, buy a garment bag from them. You can use your BK sheath. No, but I'm going to use the knife. I use the knife for sure. The sheath is too nice. I'll save that. The knife can just be washed when it's done. We'll need some fake blood for that. All right. Don't forget the evidence number cards. I've got them. Got 1 through 25 plastic tent evidence cards. Clean guard. We want the suits with hoods, right? Anyway. All right, I think we're going to go to lunch, and that will prompt Judge Boyd to come back with a verdict. So we're going to take a little bit of a break. Up to an hour. I know that's a long time, but up to an hour. We've been going for nearly 5 hours right now. So it is Friday. We hope to come back with a verdict here. Hopefully the biohazard issue at the courthouse, the Justice Center there in San Antonio, Texas, has been resolved, and we can get a verdict here without an issue. So lunch it is. Even though I've already eaten lunch, I'm just gonna shop. What time does trick or treat start? East Coast time, probably an hour before sundown, an hour before sunset, and it's done by 9. It's over by 9, I think. So I will check the portal. I've got a ton of text messages. I'll check the burner. I don't have a portal yet. Let me make a quick portal. Okay, we've got a new one set up. It's going to be set for 3. We might come back sooner. Tonight when you go home, please hug the people you love. Smile at someone to make their day just a little bit better. And please stay safe till we go live again about 3 o'clock or sooner if something happens. We'll keep our eye to the ground. If you see something before I go live, go ahead and text me on the burner phone, and I'll hope to jump right back on. We can catch the verdict that way. And that will take us to the end of the day. So we'll be back after lunch. Portal is built. I'm going to do some Halloween shopping. I'm having way too much fun doing this. All right, you guys, be good to each other. We'll see you in a little bit. Bye-bye.